before we begin, there is something that I have to do. I have to give the kitties treats, or I fear they may riot. This has been an ongoing battle. And someone is very, very unhappy about it. Would you just wait? My goodness. So we're going to start with them tonight. Come on. Yeah. We got Snitch in the little hut on the bottom there. Oh my. There. That's plenty. That is plenty for you guys. My goodness. It has been non-stop. Tap, tap, tap. Tap, tap, tap. Meow, meow, meow. And Ava, she gets spoiled tonight. So a clerk at a local store gave her these handmade bakery bones, and she goes nuts for these. One is bacon cheddar and one is peanut butter. They're like $2 at the shop. So what do you want to do for these? You want to dance? Can you show everybody your dance? Dance! Dance, Ava! Yeah! Oh! Howie! She grabbed my boob and it hurt. Oh my! Hey, be nice. There is plenty to share. Oh, Snitch. You poor thing. You poor thing. Come here. Come here, baby boy. It's okay. You get your own. Okay, there's some there. And there's some in this little curl up spot here. Yeah. Yeah. Why don't you curl up in that? Oh, you beautiful boy. Yeah, you beautiful boy. Oh my, Ava, that's already gone. That is already gone. That half. Still got this half. Not for long. No, it wasn't a rub. It was claws. They hurt. Hello, Jerry Matthew Boyd. Hello, Mortimer Duke. I'm so happy you're here tonight. Considering you fell asleep on me last night. Hello, Buzzy Pug. Hello, Nana Laura. Hello, Wire Mother. Hello, Squishy. Good to see you, buddy. I haven't checked my Discord. I bet I probably have Squishy messages in there. Hello, C-Rex Mama. You know the rules. As long as you hit like before you doze off, it's perfectly acceptable. Oh, baby girl, you ready for your other one? You ready? Oh my, you certainly are. This is the bacon and cheese. Bacon and cheddar. Oh. Yeah, you speaking? You gonna speak? Woo! You want the bigger half. It didn't break quite in half like the other one did. The other one broke perfectly. This one got stuck under the wrapper. There we go. Oh my. Okay. Whoa, don't you get my boob again. Speak. That's not it. Speak. Oh, golly, you can't even see her. Speak. Oh, fudge. Oh, well. Oh, golly. Hello, Spider-Man. Hey, I'm early. I'm early and on time. Go figure that one out. Yeah, she's gonna anyways. And by the way, hello, Manny. I know you're probably out there. Oh, we are well aware. We are well aware. Oh, golly. Okay, guys. So we get to go to Thurston County today. Or tonight. And it's a hearing from today. And then after that, we're going to go to Kansas. And we're going to see a pro se. He's not quite a savvy, but I think he really wants to be. He's kind of soft sit adjacent. He's trying all the tactics. He thinks he's really smart. It's going to be a good time tonight, guys.
All right. Sir, there at Nisqually, your name?
James Romanello.
James Anthony Romanello?
Yes, sir.
All right. All right. We are here for a conditions review hearing. All right. We've got dates currently set for trial confirmation on June 26th at 10. This hearing was scheduled by your attorney, Ms. Groth, at the Public Defender's Office to reconsider the amount of bail in the case. And let's see, Ms. Clark, are you going to be arguing that?
Yes, Your Honor. I will be covering for Ms. Groth.
All right. And give me one moment while I bring up that motion. All right. So I've had a chance to review the motion, but Ms. Clark, if there's anything further you'd like to add from your notes or for conversation with Ms. Groth.
Yes, Your Honor. Ms. Groth has told me that at the time of Mr. Romanello's bench warrant quash hearing, defense was unable to speak with him despite a request to speak with Mr. Romanello. Defense was not able to make representations at the time because they had not spoken with him. But after Ms. Groth has had the opportunity to speak with him, she's learned that he suffers from epileptic episodes for which he takes medication. I do not believe he has that medication available in the jail. Also, she has learned that he is on a fixed income and he receives Social Security benefits. The bail currently is set at $500,000. the burden to someone who is on a fixed income of Social Security is very, very high. Tantamount to a no bail hold. So despite the time that Mr. Romanello was on the warrant status, he has not had any new law violations. So in considering his age, medical status, limited income, and the lack of any new law violations during the warrant time, we're asking for a reconsideration of bail.
All right, thank you. And before I turn it over to Ms. Pritikin, I want to make sure I have it correct, because I see there's been, is bail currently set in the amount of $500,000?
Yes, Your Honor.
All right. And the reason I was asking is it looks like there's been some periodic payments of $1,000, but then it doesn't look like that's been acceptable. So I just wanted to make sure that was, wanted to make sure I was clear about that. Okay. So Mr. Romanello, you heard there from Ms. Clark, who's a colleague of your attorney's, Ms. Groth. Next, I'm going to hear from the prosecution. They've got a prosecutor here in the courtroom as well, Ms. Pritikin. Go ahead, Ms. Pritikin.
So this is not my case, so I'm just sort of getting up to speed now, but this defendant has considerable history. He has at least 10 lifetime DUIs, extensive warrant history. He had a, quote, successful deferred prosecution where he admitted that his substance use issues made him a danger to the community, and then he had 7 more subsequent DUIs, and that's why the bail was initially set so high. Just repeated DUI, even with all the rails that we could put in place. On top of that, the defendant was supposed to get treatment and then skipped out and went to Mexico. And apparently, according to the notes from May 8th of this year, he had a warrant out and he left for Mexico, defying the orders of the court. So we would ask that, given his prior history.
Yeah, it's kind of hard for him to have any violations if he's not even in this country.
We had to add escape charges at one point, and he actually had the means and ability to leave the country, that the bail needs to remain at its current level and remain in place, and he needs to remain in custody.
Thank you. Is the information about leaving the country, is that from the notes from the prior hearing?
Mm-hmm.
Okay. All right. So, Mr. Romanello, your attorney indicated that after speaking with you, she's made representations that you're on a fixed income. Is that correct?
Currently, Social Security is my only source of income.
And Your Honor, I'd like to add for the record as well that Ms. Groth states that he claimed that Mr. Romanello claims that he was in treatment during some of the warrant status time.
All right, Mr. Romanello, when were you doing treatment?
Down in moves arranged by my former wife in Mexico, down in Puerto Vallarta, Mexico. It was a 2-year inpatient voluntary alcohol rehabilitation program that I completed. Lost 13 pounds, came back to be with my wife and get some weight back on to come back to Nisqually and deal with this matter, because they originally bailed me out for $1,000 and told me not to come back. I gave them my word that I wouldn't, and so when I came back, I had completed the 2-year voluntary inpatient alcohol rehabilitation program and was coming back to get this matter taken care of and put behind me once and for all.
All right. And when was that, sir? When was that Mexico program? Was that then between 2024 and 2026?
Yes, it was. It was up until it was after the 22nd of, I believe it was May. This was started in June of 2024 and was completed in May of 2026. And that's when I came back to my home here in Olympia with my wife and was basically trying to get some of the weight back on that I had lost in the treatment program and come back and deal with this so that I could get this shit behind me. And
I can put 13 pounds on in a night. Not proud of it, not bragging, but it does happen.
just continue the program and trying to carry the message to the alcoholic who still suffers, and that's what I've turned my life over to today.
All right, sir. So the program in Mexico, is that a private facility? Private treatment
Yes,
facility?
it was a private facility, Your Honor. I mean, I have to get my wife to give me the exact name of the facility. It was an inpatient program. It was very
Sir, does
remote, but as far as facility wise, a shower, they gave you a bucket of water, and the food was very.
Sorry, Mr. Romello, I don't mean to cut you off. I do have what I'm getting at more is your wife, does she work?
My wife is retired real estate broker here in Olympia. Deschutes River Realty was her business, and she's going to be 88 years old this October, and knows her source of income is Social Security as well.
Your Honor, I have a hard time believing that if this gentleman went to treatment for over 2 years at a facility that he can't remember the name of it.
Okay. All right.
Yes. It's a Rosalie. I could get the exact name of it. I don't remember the exact name of how its verbiage is. Mexico has a certain way of.
All right. So thank you, Mr. Romanello. So at this point, I understand the amount of bail in this case is exceedingly high for a misdemeanor. I want to acknowledge that, and if bail is imposed on someone, it's to be set within their ability to pay, and that's a requirement under the rules and under the law. At this point, though, I'm not going to reduce that amount, and I'm going to tell you why. First of all, one thing that I do is I look when somebody has similar history that's relatively recent. I take a look and see what other judicial officers felt were appropriate. And in the 2019 DUI, looks like bail was set in the amount of $50,000. And now we're back with the charge, which you are presumed innocent of. But there's been a 2-year gap between the arraignment and when we're back here, and it sounds like that, for whatever reason, it may have been positive reasons through treatment, but there was during that time, it sounds like you may have gone, out of the country, and to me that does create though a risk of non-appearance that's pretty significant, and also demonstrates an ability to leave the country. So I think at this point, sir, what we're going to do is leave bail in the amount currently set. You've got an attorney from public defense that's representing you, and we have court dates that are currently set, and again that are coming up. So at this point, I'm not going to make any changes to the amount of bail that's previously been set. We're going to leave your current.
I'd like to state that is elder abuse, considered for my age, and considering the fact that I have a 27-year history of a home that's walking distance from this jail, and the 27 years I've been with my wife, I pose no risk of not showing up for a court date, and it is abusive, and for my age and condition, it's elder abuse, and that is a federal crime, and that does pack a 10-year prison term, and it do have a 95% conviction rate. I believe I'm being victimized by circumstances. The case you're referring to is 7 years ago, Your Honor. I mean, somebody with a misdemeanor.
So, Mr. Romanello, I'm gonna cut you off because I've made my decision.
Nothing in 7
years. Bail's going to remain the same. same.
A
We're
parking
gonna
ticket in 7 years, Your Honor. There hasn't.
right. We're gonna mute you, sir, because I've made my decision. All right. I've explained to you the reason why. I understand you're upset with that decision, but we're not gonna make any changes today. You have your next court date coming up on June 26th at 10 a.m. And that court date will remain in place for now. And we'll see you back on that court date. All right, you're free to be taken back, sir.
Oh, he not happy. He not happy at all. He's
And then
clearly.
let's see, we've got, ma'am, your name?
This is Jacqueline White, Your Honor.
Jacqueline White. Okay, the newly added. All right, and are you prepared with Ms. White?
Yes, Your Honor.
Come on up, Ms. White. All right, and are you, let's see, we've got a second son of God.
Mhm.
Are you
Yeah,
able to,
My name's Jasmine Hall.
Jasmine Hall. Okay, just trying to check and see who's here. All right, so you're Jasmine Hall. All right. Ms. Clark, are you ready with the folks on Zoom?
Yes, Your Honor. I know Miss Sarah Nelson is here for an arraignment as well. We could take her case first.
Okay. And we've got Ms. Hall. And Ms. Clark, we had a chance to speak with Jasmine Hall.
I've not had a chance to speak with her, Your Honor, but we can undertake it.
All right, Ms. Pritikin, is the state asking for bail for Ms. Hall?
Paul has extensive failure to appear history.
Well, let's see. It looks like we don't have any other folks here. And I don't want to rush you, Ms. Pritikin. Ms. Clark, you want to take a minute and maybe talk with
Sure.
Ms. Hall? All right. So, Ms. Hall, we have an attorney from the Public Defender's Office here in the courtroom. She's going to come out. We're going to put you in a private breakout room so the two of you can talk about the warrant. And then when you're done, we'll come back and talk about that here in court.
Great, no problem.
All right. Thank you, ma'am. Ms. Pritikin, now you've had a chance to review, or you can be asking for.
No, the state is not asking for to bail in this case.
All right, and we got Ms. Hall back. All right, so hello, Ms. Hall, and
Hello, sir.
all right, so first of all, so I've had a chance to review the docket notes in this case, and I think I just want everyone to know, it sounds like, first of all, the state's not going to be asking for bail. I represented Ms. Hall back when I was at Public Defense, it looks like, when on this very case at some of the compliance review hearings. So want to make a note of that since state's not asking for bail. Unless there's a, I guess, state object to me hearing this right now. Okay. All right. So we're going to recall the warrant. One thing maybe Ms. Clark, it might be worth getting into this now since we are here. One thing that occurred, it appears that while I was representing Ms. Hall, is originally the conditions of probation here were a domestic violence parenting class or impact of DV on children, as well as a domestic violence assessment and follow-up with treatment. On March 14th, 2024, myself and Mr. Robbins for the state were at a probation hearing where the domestic violence assessment portion of probation was waived, and that's reflected in the judgment and sentence from that hearing. Instead, it was there was a requirement to comply with behavioral health resources, which was a program sounds like Ms. Hall was involved with there. So the affirmative conditions at that point was to complete the DV parenting class and comply with the BHR program. The DV parenting class is there's a certificate of completion in the file from, looks like that was no longer an issue on probation. So all that said, and then I don't see any indication in the docket on the behavioral health resources progress. This was all back in 2024. There's been a number of hearings since then and some failures to appear. But it looks like, at least according to the docket notes here, it was primarily about that behavioral health resources issue. So I figure since the parties are here, we could sort of get caught up to speed as to what the issue is as we set other hearings. Ms. Clark, did you have a chance to speak with Ms. Hall about all that?
I did, Your Honor.
Okay.
She does not have anything related to behavioral health to turn into the court.
Okay.
She has told me that she is currently pregnant and working 80 hours a week, but she is willing to find a place close to her where she lives currently in Seattle now, where she can be able to resume mental health treatment.
Okay, so she has DV against the child charges. She hasn't completed her behavioral health treatment or submitted certificates into the court for it. And now she's pregnant. What a lovely combination.
Okay. All right. So, Ms. Hall, what we're going to do today is quash that warrant, and we're going to set another hearing. So I'm not going to make any decisions on your case today. I don't think it would probably be appropriate for me to do so anyway, since I previously represented you on this very matter. But it sounds like the parties have had a chance to get caught up to speed on what the outstanding issues are here. So we're just going to quash that warrant and set another hearing. You are able to appear remotely as you're doing now. Sounds like you're in Seattle. We've got a 40th Avenue address. Is that your current address, ma'am?
Yes, that's correct, sir.
All right. Okay. And let's double check her phone number. Make sure we've got number that receives text message reminders. Is a good number for you ending in?
No, it's whenever you're ready. 8732. I believe it's 8732. I gave the new attorney 8742. It's one of those. I don't know why I'm having like fog brain right now, but I can't even get into my phone and I can't figure out what the number is. I tried to go to about phone, but
okay. Well, I'll tell you what. Sounds like we've got your mailing address, and we're going to give you another court date here as well that you can write down. We'll try to send you a text message reminder of your next court date as well. We're going to set that out about a month. And let's go to one of the Thursday calendars. Let's just keep it at compliance at this point. All right, that's going to be July 9th at 11. And that's in this courtroom, right? We have those in here. Yeah, okay, and it's going to be right back in this courtroom. So same way you signed on today, you'll sign on again on July 9th at 11 a.m. Again, we're going to mail you notice to that Seattle address. And you've got it here too to write down. We'll try to send you a text message reminder as well. And for that hearing, ma'am, I believe, yeah, the issues the court was looking at is behavioral health resources. So if you've got any information on that you want to, provide to the court beforehand or have ready at that hearing, my suggestion would be to have those ready to go. Okay. Do you have any questions?
Do you have the Zoom meeting ID?
No, that will be on the notice you get. You can also go on the Thurston County District Court website, and right there on the landing page is a link to each courtroom for Zoom, and you just go to courtroom 2 at the date and time of your hearing.
Okay.
You can do it that way as well.
And you guys usually text like a couple days before, or?
I think so. Well, we need to make sure we have your correct phone number, though. So if you're able to, at any point, confirm that we've got your correct phone number, maybe call into the district court clerk's office when you know what that number is for sure, and just let us know what that is.
Great. Is there a way that I'm able to get my attorney's number?
Have we appointed counsel? We usually don't appoint counsel at this point. So she's got point counsel. You can contact, well, tell you what, you can contact the public defender's office. Do we have their number handy? Unless Miss Clark, did you give it that to her?
I didn't, but I can,
We'll put the public defender's phone number in the chat for you. Maybe you can
Okay.
give them a call. Yeah, and kind of that 4897. Miss Clark. All right. Once you get that number, Miss Hall, you're free to go. And again, we'll see you back here on July 9th at 11.
All right. Thank you, sir.
Thank you.
Pull up the right case file here. Okay, do we have everyone we need?
Believe so, Your Honor.
This is in the District Court of Gove County, Kansas, case number 25 CR 62, State of Kansas versus Keith Madon. May I have an announcement of appearances, please?
May it please the court, state appears by Noah Haas, Assistant Gove County Attorney.
Keith Mudon on behalf of myself.
Okay. We're here for some motions today. This matter was started with a complaint on December 29th of 25. On January 26th, 2026, the defendant made a motion for discovery. February 26th, the plaintiff responded to that discovery request. March 9th of 26, the defendant filed a motion to exclude radar evidence and a motion to dismiss based on no tuning fork information. A motion regarding missing discovery, the tuning forks. We had a response from the plaintiff. On March 17th, the defendant filed the motion to suppress based on his allegations of abuse of his constitutional rights. The state had also responded to that as well on March 9th. I'm not sure how that worked with the filing, that you were able to respond before something got filed, but that's the way it worked out. You had a separate response, defendant, on March 18th to the state's response. On April 8th, the plaintiff sent the defendant additional radar certification and policy guidelines. On April 24th, the defendant supplemented his reply to the state. On May 4th of 2026, the defendant filed 5 different pleadings, including a motion for pretrial evidentiary hearing, which we are doing today, a supplemental brief on the suppression issue, a revised brief concerning these issues.
So, in a nutshell, this guy is attempting the tactic that we most often see in Cowlitz County, where he's trying to get the original stop disqualified, and then everything under it doesn't count.
A brief laying out the chronological fact pattern as the defendant understands it. And finally, a memorandum that was filed in support of an examination, the officer testifying, and I see the officer present. So would counsel agree with me that the issue today to be dealt with is the motion to suppress and accompanying motion to dismiss filed by the defendant? Mr.
Yes, Your
Hall. Mr. Madon.
Yes, Your Honor.
Okay. Mr. Madon, would you like to make a brief statement outlining the facts that you believe give rise to suppressing the evidence, which, if the evidence is suppressed, thus gives rise to your motion to dismiss? I.e., would you like to make an opening statement, Mr. Madon?
Yes, Your Honor. It's just the simple fact that the radar evidence is outdated. The 24 test is missing, and um I do want to cross-examine the trooper at some point so I can clarify some misunderstanding of what's going on in this case as far as if the state is relying on radar or if they're relying on visual estimation.
Well, you'll have the opportunity to cross-examine the witness. Okay,
Understood.
okay. And Mr. Madon, let me take care of a couple of housekeeping matters here. One, we're doing this hearing by Zoom, mostly for your convenience. Where are you at right now?
I'm at my residence, my home,
Which is where?
Georgia, 63.
Okay.
They have my address, 6355 Klondike River Road.
Okay. So it's your request to do this hearing by Zoom.
Um, the state put in that order, but I didn't object to it.
Okay. You don't object to doing this hearing by Zoom.
No, Your Honor.
A little more convenient for you from Georgia to do it by Zoom.
Yes, Your Honor.
Okay. Second thing, you're representing yourself in this matter.
Yes, Your Honor.
Okay. You understand that the first three charges are Class B misdemeanors.
Yes, Your Honor.
And if convicted, you could face up to 6 months in county jail and up to $1,000 fine on each conviction.
Yes, Your Honor.
And then count 4 is a traffic infraction for speeding. If convicted, you're facing a fine.
Yes, Your Honor.
Okay. Knowing that, is it still your desire to represent yourself in this matter?
Yes, Your Honor.
Okay. And you have not requested counsel in this matter?
No, Your Honor.
Okay. Mr. Haas, you have an opening that you'd like to make?
Yes, Your Honor. This hearing is about whether the state can prove that the stop and the resulting seizure was lawful. The evidence will show that it can. This was a pretty routine stop. Trooper Dusty Tall was on patrol on I-70 in Gove County. He observed an eastbound passenger car approaching at a speed he believed was above the posted 75-mile-per-hour limit. His radar also indicated 99 miles per hour. He turned around, activated his emergency lights, and conducted a traffic stop for speeding. After the lawful stop, dispatch returned the driver as revoked. Trooper Tall then had probable cause to arrest for driving while revoked. The search incident to that arrest produced the marijuana and paraphernalia evidence. Because the stop, arrest, and search were lawful, the motion to suppress and the request to dismiss should be denied.
And Mr. Madon, even though you filed the motion, and this is your motion to dismiss, pursuant to Kansas procedure, the state has the obligation to come forward with evidence concerning your motion. So the state will call their witnesses first. You'll then have a chance to cross-examine their witnesses. Then you'll have an opportunity to call any witnesses you wish to call, including yourself if you'd like to testify. You understand you don't have to testify, that you have the right not to testify in this matter, but you also have the right to testify if you wish to.
Understood, Your Honor.
Okay. So, Mr. Haas, if you'd go forward, who's your first witness?
Your Honor, just briefly, to be frank, I've never done a trial with evidence over Zoom. I don't know the court's preference in introducing exhibits. I do have a video exhibit and a few document exhibits. Would you like me to put them in the chat, share my screen?
Well, when the time comes, if admitted, you'll share your screen and
Okay.
allow all the parties to view it that way.
Okay.
Okay. Now, Mr. Mandon, if you would ask then, once a document is admitted or a video is admitted, if you want the state to also put it in the chat for you, that is certainly possible.
Understood, Your Honor.
Okay, but first you'll share it, screen share it, okay?
Okay.
And then you can put it in the chat, Mr. Haas, if Mr. Madon wants that.
Yes, Your Honor. Thank you.
Okay. Who is your first witness?
Your Honor, I would like to call Trooper Dusty Tall to the stand to testify.
Trooper, if you'd raise your right hand, please. You solemnly swear and/or affirm that all testimony you give here today will be the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
Yes, I do.
Are you currently in the state of Kansas?
Yes, sir.
Okay. And looks like you're in the driver's seat. Are you pulled over or parked somewhere?
Yes, sir. I'm in a KDOT parking lot, so I should be safe here. Thank you.
Excellent. I don't want you out on the roadway. Okay. Go ahead, Mr. Haas.
Thank you, Your Honor. Would you please state your name, rank, and agency?
My name is Dusty Tall. I'm a lieutenant with the Kansas Highway Patrol.
And how long have you been a Kansas Highway Patrol trooper?
For a month shy of 10 years, sir.
And what patrol area were you assigned to on November 28th, 2025?
I'm assigned to Troop D, which is Northwest Kansas.
And were you on duty and in uniform that night?
Yes, I was.
What vehicle were you operating?
I was operating a marked Kansas Highway Patrol Dodge Durango patrol unit.
And could you describe your training and experience in traffic enforcement generally?
So I was, prior to being with the Kansas Highway Patrol, I was a county deputy. So there I attended the Kansas Law Enforcement Training Center's basic training academy, followed by on-the-job training and some more continuing education there. In 2016, I joined the Kansas Highway Patrol and completed their basic training academy with obviously a focus on traffic enforcement of the traffic laws of the state of Kansas, and then continued training after that, and on-the-job training from my field training officers and such.
I apologize. I did not catch the year you went through the Kansas Law Enforcement Training Center.
I apologize, sir. I don't believe I stated that. That was 2011.
2011. Okay. Go ahead.
Can you describe your training and estimating vehicle speed by observation?
Well, in both training academies, there is a portion of the academy, a class, I guess, specifically for radar usage and speed estimation. This will include doing live speed estimations on vehicles on a closed course with known and unknown speeds. Later in my career, in 2023, I returned to the Kansas Highway Patrol's training center and completed a radar instructor course, which is more in-depth knowledge on the use and some of the theory behind the radar, as well as some case law and stuff like that. Also included in that is some more speed estimations, and then daily on the road, there's speed estimations that are followed up by confirmation with the radar unit that I've been assigned.
Can you describe your training and experience with radar equipment, including the Stalker DSR 2X?
For that particular unit, which is what I currently operate, that's the unit that I was trained on going through the Kansas Highway Patrol's Academy through my field training portion of my employment here, and again at the radar instructor course. That's the primary unit of the agency, so that's the one that I was trained on.
And how often do you use radar in traffic enforcement?
On nearly a daily basis with my patrol duties.
Nearly a daily basis in your roughly 10 years of experience. So would it be fair to say well over 1,000 days of work on the highways?
Yes, sir. I think that would be very fair to say.
Where were you before the stop?
Prior to the stop on November 28th, I was westbound on Interstate 70 near milepost 113 within Gove County, Kansas.
And what direction were you traveling?
I was westbound.
And what was the posted speed limit at that location?
It is 75 miles per hour.
And what were the lighting, traffic, and weather conditions?
It was a clear night. The roadway was dry and fine. The lighting in that area is basically non-existent, and the traffic was very light.
Did anything obstruct your view of eastbound traffic?
No, sir.
When did you first notice the defendant vehicle?
Again, as I was traveling west, I observed some headlights coming towards me in the distance.
And what drew your attention to that vehicle?
As I noticed it closing with my patrol unit, based upon other traffic that I had seen previously that night, it appeared to be closing at a very high rate of speed.
Based on only your observation before relying on any later report, did the vehicle appear to be traveling above the posted 75-mile-per-hour limit?
Yes, it did.
And what about its movement led you to that conclusion?
Again, just the rate at which it was closing on my patrol unit. I generally patrol with the cruise control on, and as I'm watching one vehicle come at me versus the next one, that the defendant's vehicle was closing rapidly.
Do those observations include the distance covered by that vehicle?
Yes.
And does it include comparisons to normal interstate traffic you had observed prior to that stop?
Yes.
Were you able to form an opinion based on your training and experience that the vehicle was speeding before the stop?
Yes, I was.
When you say that the vehicle was speeding, do you merely mean it was moving quickly or that you believed it was exceeding the posted speed limit?
Yes, in fairness, 75 miles per hour is quickly, but this was in excess of that.
And you could tell that from your visual observation?
Yes, sir.
And was your visual observation made before you saw the radar speed?
Yes, as a practice, I observe a vehicle and then activate my radar to confirm my suspicion that it is in excess of the speed limit.
So that observation contributed to your decision to stop the vehicle?
Yes.
If the radar had not displayed a number, would your visual observation have caused you to further investigate the stop for speeding?
Yes, it would.
And why is that?
Again, because it appeared to be moving in excess of the posted speed limit.
Was your patrol vehicle equipped with a radar unit?
Yes, it was.
Do you know the make, model, and serial number?
I'll have to refer to my paperwork here, but yes, I do. It is a Stalker DSR 2X. The main serial number on that one is DI 096976.
Was the radar unit on and operating before the stop?
Yes, it was.
What reading did you observe for the defendant vehicle?
The radar unit indicated that the vehicle was traveling at 99 miles per hour.
And how did you associate that reading with the defendant vehicle rather than another vehicle?
At that time, again, the traffic was very light on interstate, and there were no other vehicles in my field of view at that time.
And was the reading consistent with what you visually observed?
Yes, it was.
Did you have any reason at the time to believe the reading was erroneous?
No, I did not.
Were you qualified to operate the Stalker DSR 2X unit on November 28th, 2025?
Yes, I was.
What's the standard practice for checking the radar unit at the beginning of a shift?
In accordance with the Highway Patrol's policy, as well as the manufacturer's recommendations, a self-test is conducted prior to and following a tour of duty.
And did you follow that practice on the shift, the date of the incident at issue?
Yes, I did.
Can you describe just step by step how those checks are performed before and after patrol?
It's an actually extremely easy procedure. There's a test button on the radar's remote control. I depress that button. The radar itself goes through a series of self checks, and at the conclusion of those checks, it displays on the screen the word pass if it is operating correctly and functioning like it should. If it detects some sort of issue with the machine, then it will display the word fail. On the date in question, it displayed the word pass.
Did you perform any end of shift or post stop check?
Yes, it did.
And was it pass for both the pre-shift and the post shift or the post stop?
Yes, it was.
And did you perform a tuning fork test?
I did not.
And why is that?
Because as I stated previously, the Highway Patrol's policy, in alignment with the manufacturer's guidelines, does not call for that at this point.
And do you maintain any daily written calibration logs for the unit?
No, I do not.
And can you explain why that is?
The Kansas Highway Patrol has no policy implemented to require that, nor have I seen that in practice from any of my training officers or in any classes I've attended in reference to radar operation.
Were you aware of any malfunction, repair issue, or accuracy complaint for the unit that night?
No.
So the radar was in proper working order when you obtained the 99 mile per hour reading?
That is correct.
After observing the speeding violation, what did you do?
After I observed the vehicle and obtained a reading with my radar, I met the vehicle. Again, he was eastbound, I was westbound. So once he passed my location, I turned around, activated my emergency lights, and conducted a traffic stop.
And did the vehicle stop?
Yes, it did come to a proper stop on the right shoulder.
Who was driving?
The driver was identified by his Georgia ID card as Keith Moudon, with the date of birth April 1st, 1998.
And is that the same Keith Moudon who's present today via Zoom?
It appears to be.
And did you run the driver through dispatch?
Yes, I did.
What did dispatch report regarding the driver's status?
My dispatch checked the driver's license, or the identification card rather, through their computer system, informed me that the driver had a revoked driver's license, and they additionally went through some extra steps of checking all 50 states for other identifications for him to see if he had a valid license throughout some other state, and found none.
So based on that information, what action did you take?
I placed the driver under arrest.
And after the arrest, did you search the defendant?
Yes, I conducted a standard pat down of the arrestee, following placing him in handcuffs.
And what's the purpose of that standard pat down?
Primarily, that is for checking for weapons, for officer safety, as well as safety of the arrestee. However, it also is intended to prevent contraband from entering the jail upon my arrival at the jail.
What, if anything, did you locate?
In the arrestee's right cargo pocket on his pants, I located 2 plastic containers, each of which contained a marijuana joint.
And did you seize and preserve those items?
Yes, I did.
So some documents spell the defendant name differently. Is that a clerical error?
Yes, I noticed that when preparing for this case that I had spelled the defendant's last name as Mundon, Mundon. I'm not sure if that was an autocorrect thing or it was an issue on my end, but as I reviewed the photo that I took of his identification card, I see that clearly I did not get it spelled correctly on my documents.
Does that spelling change anything that you observed before the stop?
No, it does not.
So the arrest report and the offense report use dates around midnight. Can you just explain why one document may reflect 11/28 and another, the arresting document, 11/29?
That could simply be when I started using the document and the time I referred to on the dispatch log. I may have inadvertently looked at two different entries that my dispatchers had made and used them for the same item. I'm not sure exactly what you're referring to at this time, though.
Well, I'm referring to the observation of the incident being on 11/28, but the actual arrest being at 12:01 a.m. on 11/29.
I apologize. I misunderstood your question there. Yes, oftentimes things that happen near midnight will begin on one date and finish on the next.
Your Honor, I would like to share screens to present some exhibits for identification.
Okay. First, tell me what you're going to share.
Okay, Your Honor, I intend to share the certification of the radar and the radar instructor certificate.
Okay, one at a time, please. What document do you want to start with?
Okay, Your Honor, Exhibit A for identification, the Kansas State Trooper Tuning Fork Certification of Accuracy.
Any objection to his sharing that, Mr. Mendon?
No, Your Honor.
You may share that document.
Can everybody see the proposed exhibit for identification?
You might zoom in just a little bit there. Lower right-hand corner, there's a little spyglass with a plus and a minus. One more click on that plus. There you go.
Your Honor, shall I scroll down to show the complete exhibit for identification?
Go ahead. Wait a minute, you went too fast. You needed to go half a sheet, then half a sheet. Give us time to read it. Okay. 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 Mr. Madon, holler if he's scrolling too fast, okay?
Understood, Your Honor.
To be fair, I did speed it up and cut out the sections where they just paused for long periods of time. If you guys want to go back and read the actual certification, you can always pause on it and read it. But it's really just saying that the device has been certified. and they go through and verbalize it anyways. So
Okay.
That is the end of Exhibit A for identification, Your Honor. Lieutenant Tall, do you know what this is?
So the first two pages are recertifying that the tuning forks, which again were not used in this particular instance, but showing that they are still within compliance. The second two pages, the Doppler radar certification form, is our triannual recertification of for a radar operator with Kansas Highway Patrol, and just showing that those have been completed and it was completed satisfactorily.
Okay, Your Honor, I move to admit Exhibit A.
Any objection, Mr. Madon?
No, Your Honor.
A is admitted.
Lieutenant Tall, the date on these certifications is May 1, 2023. Is that correct?
Yes, it is.
And can you explain the certification window, whether the date of the stop fell within that certification window, and the general practice of the Kansas Highway Troopers in regards to radar certifications?
Yes, per policy, it is again, triannual every 3 years that we are recertified. I believe there is some grace period allowed. I couldn't tell you exactly what that time frame is beyond that 3 years without having referred to that policy again. However, the stop in question was certainly less than 3 full years from the date of that recertification.
Thank you, Your Honor. I'd like to put forth Exhibit B for identification.
Go ahead. You've got a little rotate arrow 2 above the plus. Thank you.
Lieutenant Tall, do you know what this is?
Yes, this is a certificate of completion for the radar instructor course, which I attended at the Kansas Highway Patrol's Training Center in 2023, and just indicating a higher level of education and expertise with that particular unit, and the ability to train new officers and to be able to do the recertifications that we referred to from Exhibit A there.
Your Honor, I move to admit State's Exhibit B.
Any objection, Mr. Madon?
No, Your Honor.
B is admitted.
Lieutenant Tall, how much time did you spend getting the certification?
This particular course, as indicated on here, was November 28th through December 1st. I believe it was a 4-day class. So
does it indicate
probably,
you spent about 28 hours of training?
Yes.
And you believe that's accurate?
Yes.
Your Honor, I'd like to present State's Exhibit C for identification. It's video evidence.
And is that the video from that night?
Yes, Your Honor.
Mr. Madon, do you have any objection to him showing the video before he admits it?
No, Your Honor.
Go ahead.
So, Lieutenant Tall, I would ask that you watch this snippet of the video, and then I'll have some questions for you. Just stop right there. First, Lieutenant Tall, do you know what this is?
Yes, I do.
What is this?
This is a copy of the car camera footage from the night of the stop. I had a chance to review it this morning, so that's why I recognize this in particular.
Thank you. Your Honor, I move to admit Exhibit C.
Any objection, Mr.
No,
Madon?
Your Honor.
C is admitted.
And Lieutenant Tall, I stopped it right before you were entering the left lane there. Can you explain why you entered the left lane there if the defendant's vehicle is in view, and a little bit more about what's going on at this moment in time?
Yes, as you saw leading up to this, I was traveling in the right lane, had seen one other vehicle pass, then noticed this one again that we described earlier, approaching at a high rate of speed. I moved to the left lane to prepare to turn around in the median so that I could conduct a traffic stop.
And we saw the preceding seconds, but just for the court, and given your experience, is there any other vehicle that could have possibly triggered your radar at that moment?
No, sir.
Thank you.
Oh my gosh. The trooper didn't even wait till he got to a medium. he crossed over the or he crossed over the dirt, the ditch. Oh my, he wanted to get him. He didn't even wait for the break in the median. He's taking his sweet time. It's probably tucking those couple little containers of marijuana cigarettes.
And Lieutenant Tall, is that car that's stopping right now, the vehicle that you pulled over that Mr. Mudon was the driver for?
That's correct.
Thank you. I have no further questions and no further exhibits.
Are you then limiting your information to just the stop itself?
With that inquiry from the court, the state would like to proceed to the probable cause up to the arrest and continue with the exhibit.
Okay.
And Lieutenant Tall, at this time, are you speaking with the defendant, Mr. Mudon? I believe you're muted again.
I apologize. Yes, at that time I am speaking with him. There's no audio of my encounter with him on this particular video that would be accompanying the body cam footage.
Do you remember what he just gave you, Lieutenant Tall?
Yes, he presented me with a Georgia identification card.
Did you believe it to be proper licensing to operate a vehicle?
No, I did not.
Lieutenant Tall, can you explain a little bit about your conversation after receiving the ID that you did not believe to be a proper operating license?
So again, when he handed me the identification card, which is clearly indicated on the card itself, I inquired why he did not have or asked him if he had a driver's license. He told me that he did, but in Georgia, everyone just uses their ID card. I again found that to be highly improbable.
Hey, man, I did what I could with what I had.
Lieutenant Tall, I'm not sure how much the audio picks up here. Can you explain to us what's going on? And you're muted again, Lieutenant.
I apologize. I am not a computer guy, clearly. At this time, I'm sitting in my vehicle, inputting the driver's information into our CAD system for dispatch to check. And at some point during my time in the vehicle, I received word from dispatch that he has a revoked license and multiple suspensions.
Mr. Haas, is there audio with this video?
Your Honor, the audio is there in the background. It's probably pretty hard to hear.
Okay.
I can try turning it up on my end here.
Narrator says, but there was no audio.
I'm going to try scrolling forward to a more relevant section of the video.
Any objection to that, Mr. Mundon?
No, Your Honor.
Okay.
So, Lieutenant Tall, can you tell us what was going on as you approached the car?
So again, by this point, my dispatcher informed me he had a revoked license. I had made the decision to arrest him for that offense, and at that point, I was approaching the car to ask him to step out.
Did you have any reason to believe this was some kind of mistake in record keeping?
No, I did not. Based upon the ID card that he provided and the return from dispatch, I believe that to be an accurate description of what was going on.
And is it fair to say at that time you fully believed that you had probable cause that he in fact did have a revoked license?
Yes.
Is that what made you initiate an arrest?
Yes, it is.
Do you remember what you just asked him?
I asked him to hop out and talk with me at the back of his car, something to that effect.
Is this when you were effectuating that arrest based on your belief that a misdemeanor had been committed?
That's correct.
Well, remember,
Can you explain what's occurring now?
this is just a motions hearing. This isn't even his trial or bench trial or anything. He's just trying to get all of the evidence thrown out so that he can request the case dismissed.
There, I'm conducting a pat down of his person, again, primarily for weapons, but also for contraband that could be introduced into the jail. In that side leg pocket on his pants there, I've discovered the two plastic containers, each containing a marijuana joint.
Based on your experience, was the time it took to investigate the defendant's driving status reasonable?
Yes, it was.
I do wish they used the body cam footage.
At this point, did you have further reason to believe an arrest should be effectuated?
Yes, at this point, in addition to the revoked driver's license, I also had the offenses of possession of marijuana and paraphernalia.
He's looking like he wants to run.
Lieutenant Tall, was there any other further incident of note after you effectuated the arrest?
Following this arrest, placed him in the front seat of my patrol car, secured him there. I did speak at some length with his passenger. I don't know if that's his wife or who exactly that was, a female of some sort. Just kind of getting her straightened out on exactly where he was going and how to get safely to the next place where she could get a stop and get her affairs in order. But that was it of note.
And what did you do with the marijuana?
It was collected again from him, placed in my patrol vehicle until I was able to get to a troop office where it was packaged up according to our evidence packaging procedures, and later transported to KBI for testing to determine the contents.
And during the course of that custody, was there any irregularity other than your normal operating procedure for getting evidence to KBI?
No, there was no variation from the norm there.
Your Honor, I'd like to present one last piece of evidence for identification. I'd ask if I could just stop sharing my screen briefly while I pull it up. I'm not entirely sure what's on the background, but I don't want to risk any accidental disclosures. It'll take just a moment.
Okay.
Your Honor, this is State's Exhibit D for identification.
Might have to enhance that just a little bit.
This is the lab report for the THC.
Are you able to see that, Mr. Madon? Is that large enough to view?
Yes, Your Honor.
Okay.
Lieutenant Tall, do you know what this is?
Yes, that is the typical receipt we get from the Kansas Bureau of Investigation upon their conclusion of testing of an item we've submitted.
Your Honor, I move to admit State's Exhibit D.
Any objection, Mr. Madon?
No, Your Honor.
D is admitted.
Lieutenant Tall, can you explain to us the results of this lab analysis?
Yes, this would be for the items, the two containers that we spoke about previously. I took out of Mr. Madon's pocket. They were sent in, and it appears that the results and conclusion line there says that marijuana was detected in lab item number 1, and it provides a net weight of the contents of 0.85 grams.
Thank you, Lieutenant Tall. The state has no further questions or exhibits.
Mr. Madon, would you like to question the officer?
Yes, Your Honor.
Go ahead.
Good afternoon, Trooper Tao.
Hi.
Trooper Tao, you initiated a stop on November 28, 2025 at approximately 11:47 p.m., correct?
Yes, sir.
You were traveling westbound on I-70 when you observed my vehicle traveling eastbound.
That's correct.
You turned
Hey,
around.
Just a second. Mr. Haas,
Yes, Your Honor.
would you stop sharing your screen, please?
Yes, Your Honor.
Thank you. Go ahead, Mr. Madon.
Okay. Where was I? You turned around, activated your emergency lights, and conducted the stop, correct?
Yes.
In your sworn narrative that you submitted to the court, you wrote that your vehicle radar indicated that I was traveling 99 miles per hour. Those are your words, correct?
That sounds correct.
On the arrest report, under the reason for stop, you wrote 99 in the 75. The radar reading again that you saw. That's correct, right? Like on the arrest report, you wrote down 99 or 75. I'm just trying to clarify that. You actually wrote that down on the arrest report. Yes or
Okay.
no?
Yes, that would indicate 99 miles per hour and a 75
Yeah,
mile
I'm
per hour.
sorry. That's what I was trying to clarify. When you entered the reason for the stop into your CAD system at 1:14 in the morning, you typed again reason for the stop 99 in the 75.
That sounds very plausible. I don't have the CAD report in front of me.
That's fine. So across all official documents you completed that night, you identified the radar reading as the reason for the stop, correct?
The reason for stop was that the vehicle was in excess of the posted speed limit.
Understood. But across all official documents that you wrote that night, you identified the reason for the stop being me speeding 99 or 75 and using your radar as official instrument to pull me over.
Yes, it is an instrument that is used to give a definite speed that is being traveled. Yes.
So nowhere in the arrest report, the criminal investigation record, your CAD entry, did you write anywhere visual estimation or visual observation as the reason for the stop?
I actually have my narrative in front of me, and I'll read to you the line ahead of the one you read out loud earlier. It says, as I traveled west on I-70 near milepost 113, I observed an eastbound passenger car approaching at a high rate of speed. That would be my observation of it, sir.
The certifications for that radar unit are dated May 1st, 2023, over 30 months before the stop, correct?
More than 3 months before?
30
Yes.
months, over 30 months before the stop.
That sounds plausible.
No daily calibration log exists for that unit for November 28, 2025, correct?
Correct. We do not do a daily calibration log.
No body camera footage shows the radar displaying radar reading 99 miles per hour.
No, the body cam's not activated until my lights are turned on.
Okay. Moving forward, I just want to address the 87 minute gap. So the stop happened at 11:47 p.m. You had me in custody by 12 a.m., correct?
I don't have the time of arrest here directly in front of me, but
Yeah, it happened at
11:47 to
11:47.
midnight sounds about right.
Okay. The first time 99 miles per hour in the 75 appears anywhere in the official record is at 1:14 a.m. That's 87 minutes after the stop, entered by you personally while you were at the evidence office, correct?
I certainly don't recall where I would have entered that into the CAD.
Well, that's what's reported to the court.
His eyes just are driving me crazy. Through the whole editing process, they were too. I don't know if it's him skimming the documents that he's reading or what it is, but they're just doing this the whole time and not I don't know, it's just not right. I think he might be under the influence of something.
8 minutes before that entry, dispatch had just emailed you my criminal history and driving records, correct?
I again don't have the timeline of the emails, but I presume they would have emailed me that.
And then you entered the reason and the charges in the same 2 minute window. Again, 99 miles per hour in a 75 due to radar reading.
I can't I'll tell you the exact timeline
Okay.
of when that was written
I just
down,
have
sir.
one last question for you, Trooper. Just one last question. Your
Okay.
eyes or your radar? Which are you leaning towards? Because every document you sign in and submitted to the court says you pulled me over because of your radar reading and you activated your lights because of your radar reading. So, and now you're stating that you visually estimated my speed to pull me over because you saw me closing rapidly and I appear to be moving in excess of the speed limit. So you can't really have it both ways. You either saw me coming fast or your radar alerted you that I was going fast. So which is it?
So it's the totality of the circumstances, sir. I observe you going at a high rate of speed, and the vehicle radar confirms my observations.
Understood. You observed me, but every record you submitted stated you lean towards the radar being the reason for the stop.
Again, my narrative, as I read to you a moment ago, has both those things in there.
Understood. I rest my case, Your Honor.
You have no additional questions, Mr. McDonald?
No, Your Honor.
Okay. Do you have any additional witnesses, Mr. Haas?
No, Your Honor. Brief redirect, if that's permitted.
Okay, go ahead.
Trooper Tall, given your experience, is it pretty common when you catch somebody on radar to also observe that they are speeding?
Yes, it's required that we have a visual confirmation as well as an auditory tone, which we did not cover previously, but there was an auditory tone that accompanied the reading on the radar. So you have to have all three of those things together.
Yeah, I mean, you have to first see that someone's going fast before you have a reason to hit him with the radar. Like, I don't understand this guy's argument. Trooper, are you relying on the fact that you saw me going fast or that your radar said I was going fast? Like, both. Because he wouldn't have put the radar on you if he hadn't seen you. You're an idiot.
In fact, given your training at observing and estimating the speed of vehicles, it would stand to reason that if the radar picks them up speeding, you would also observe them speeding. Is that correct?
Yes, sir.
Is it common to list every single reason you believe the person to be speeding in a dispatch call?
No, that would certainly clog up the CAD.
Is it standard practice to sometimes call dispatch after an arrest has been effectuated?
Yes, that's very common because things need to be taken care of in a quick and orderly manner on the side of the road for the safety of all involved.
So the dispatch call didn't have anything to do with your reason for stopping the car at the time, with your observations, with your experience. is it fair to say that your call with dispatch was irrelevant to that stop?
Yes.
No further questions, Your Honor.
Recross, Mr. Madon.
Your Honor, I do have additional question to. I really want to isolate this whole visual versus radar situation they got going on. So I would like to ask Trooper Tao.
Well, ask your questions. If Mr. Haas has an objection, he'll make it.
Okay, thank you, Your Honor. Okay, let's separate that radar versus visual. Starting with the visual observation, at the moment you activated your lights, what was your specific estimate of my speed in miles per hour?
At the time that I activated my lights, so
Yes.
after I turned around on you, is that what you're asking me?
At the moment you activated your lights, what was your specific estimate of my speed in miles per hour?
By the time I turned around and activated my lights, I was not making an estimate of your speed. I was already done with that portion.
So, but when you earlier said you observed me visually, you mentioned I was going in excess of the speed limit, right? Like you said, I was closing in rapidly. That caused you to assert your visual estimation, correct?
Yes.
Okay, high rate of speed in the language you use, like that's a general description. That's not a specific estimate of speed, correct?
Correct.
In rapidly, okay. But you did note that the radar reading in your narrative was well, not, let me back up. You did note in your arrest report that the radar reading was documented at 99 to 75, correct?
Correct.
Now the radar, the certifications that the unit were 30 months old at the time of the stop, that's still true, correct?
Yes, and well within of our policy guidelines.
And again, no daily calibration log exists for November 28th, 2025.
Yes, again, in accordance with my policies.
No body camera footage shows the radar display.
I don't believe it would show the radar display because it doesn't turn on until after I activate my lights.
And the official record of that radar, the official record of that reading is your CAD entry at 1:14 a.m., 87 minutes after the stop, correct? At the evidence office while you're at the office.
That would have been an entry of that number.
Trooper, if the visual observation was independently sufficient, why does every document you sign says 99 in a 75 as a reason for the stop?
Because that's the instrument that I have for measuring exact speed. So I want to be as precise as possible.
If the radar was independently sufficient, why does the only if the radar reading was independently sufficient, why does the only official record of that reading appear 87 minutes after the stop?
The radar is not independently sufficient to tell that someone was speeding.
On the night of November 28, 2025, you did not write visual observation in any stop.
Objection, Your Honor. That asked and answered.
Well, you've gone over it several times, but that particular question has not been asked and answered. We're finally getting to, I think, what Mr. Madon's objection is. So go ahead, Mr. Madon.
On the night of November 28, 2025, you did not write visual observation in any stop reason field. You did not enter the radar reading into the CAD until 1:14 a.m. What you had in real time at 11:47 was neither a documented visual estimate nor a recorded radar reading, correct?
I certainly couldn't tell you the first time that I wrote it down. I know the first time I said it out loud was when I made contact with you initially.
So what you're telling this court is that you relied on both a general impression with no specific speed estimate and a radar reading that wasn't entered into the official record until 87 minutes after the arrest. That is the complete foundation for this stop, correct?
I don't believe that's correct.
That's it, Your Honor.
Okay. Do you have any additional witnesses, Mr. Haas?
No, Your Honor.
Do you have any witnesses, Mr. Madon?
No, Your Honor.
And you have a right to testify if you wish, but you don't have to.
I do not wish to testify, Your Honor.
Okay. Close, Mr. Haas?
Yeah, Your Honor. Yes, Your Honor. The state's met its burden. The law does not require perfect paperwork. It requires a lawful basis at the time of seizure. Trooper Tall supplied that basis. He observed the defendant vehicle traveling above the posted 75-mile-per-hour limit. His radar indicated 99 miles per hour. Under Kansas law, an officer who observes a vehicle exceeding the speed limit has authority to stop it. It's in State v. Guy. Under State v. Butts, a trained officer's visual estimation that a vehicle is exceeding the posted limit may itself constitute reasonable suspicion under the totality of the circumstances. The defense is trying to convert a later dispatch entry into a defect, but the law asks what the officer knew when he was activating his emergency lights. The dispatch entry is an administrative documentation, and it doesn't erase the roadside observations or the radar indication. It doesn't prove fabrication, and it doesn't change the fact that the reason for the stop was speeding. Defense is also challenging the radar foundation. State v. Prem tells us how radar evidence is admitted through operator qualification, proper operation, and testing in accordance with accepted procedures. The trooper testified to those points. In any event, the stop does not fail merely because the defense disputes the ultimate weight or admissibility of the radar reading. The visual speeding observation independently supports reasonable suspicion. Once the vehicle was lawfully stopped, dispatch returned the driver as revoked. That gave probable cause to arrest for driving while revoked. The search of the defendant after arrest produced the drug evidence. Because the stop and the arrest were lawful, there is no evidence to suppress here. Finally, the request to dismiss all counts. It's not a proper pretrial substitute for trial. The court can deny suppression today. Questions about final proof of each element are for trial or for a proper motion. For judgment of acquittal, the state asked the court deny the motion to suppress and deny the request to dismiss.
Mr. Madon, your argument.
Your Honor, this case comes down to a single constitutional question. At 11:47 p.m. on November 28, 2025, when Trooper Tao activated his emergency lights and seized my person on I-70, did he possess the specific articulable facts that the Fourth Amendment requires? Not what he believed in retrospect, not what the state argues today, what he actually had at that moment. The record answers that question, Your Honor, and the record is the state's own. What the state has. The state has offered two theories to justify the stop: a radar reading of 99 miles per hour and a visual observation of a vehicle traveling at closing rapidly, per the trooper's words. The radar reading. The radar for that unit are dated May 1st, 2023, 30 months before the stop. The state has admitted on the record that no daily calibration log exists for November 28, 2025. No body camera footage shows the radar display. And the first time that number 99 and the 75 appears in any official record is at 1:14 in the morning, 87 minutes after the stop, 73 minutes after I was already in custody, entered by the trooper himself. Personally, while I was sitting at the evidence office in Wikini, 8 minutes after the dispatch had just transmitted my criminal history and driving records to him. That is not a contemporaneous radar reading. That is a number entered during post-arrest administrative processing from a device with no documented shift level verification on 30-month-old certifications with no video corroboration. Now, the visual observation. The trooper wrote in his own sworn narrative that he observed the vehicle approaching at a high rate of speed. That phrase contains no estimated speed, no comparison to the posted limit, no specific articulable basis for concluding a particular violation had occurred. It is a general impression that the kind of description that could fit any vehicle on a Kansas highway at night. When this court asked the trooper on cross-examination what his specific miles per hour estimated was at the moment he activated his lights, he could not give one. And here is what the visual observation theory is impossible to accept. The trooper himself never used it as the reason for the stop in a single official document he signed. The arrest report says speed 99 in a 75. The criminal investigation record says traffic stop for speed 99 in a 75. His own CAD entry says reason for stop 99 in a 75. 3 official separate documents. 3 times he chose the radar number. Not once did he write visual observation in a reason for the stop. The state's lawyers introduced the visual observation theory in a legal brief filed months after the stop, after the radar certifications were challenged. The trooper's own documents do not support it. What the Fourth Amendment requires. Terry v. Ohio requires specific articulable facts known to the officer at the moment of the seizure, not developed afterwards. No, not assembled during evidence processing, not argued by counsel in brief, what the officer actually possessed and relied on at 11:40. Trooper Tao had a general visual impression he could not quantify, and a radar reading from a device with no documented shift level verification, and would not appear in any official record for another 87 minutes. That is not reasonable suspicion. That's noise by the state trying to persuade the court. If this stop lacked a constitutionally adequate basis, everything that followed is fruit of the poisonous tree. The search of my person, the marijuana evidence underlying counts 1 and 2, the revoked license determination that arose only because the stop was made, the casual chain from the unlawful seizure to every piece of evidence in this case is direct and unbroken. The state has no independent source. Every count tracks back to 11:47 p.m. on November 28th, 2025. If that moment cannot be justified and on this record, it cannot, none of what follow can stand. Your Honor, I am asking this court to do what the Fourth Amendment requires. Look at what the officer actually had at the moment of the seizure and not what the state wishes he had, not what he entered into CAD system 87 minutes later at evidence office. Look at what the documents the trooper himself signed. They tell you what he relied on. They say 99 in a 75 every time. That reading is unverified, undocumented for the shift, and entered into the official record under circumstances this court has now examined in full. Your Honor, I request this court to suppress the evidence, dismiss counts 1 and 2. The stop cannot carry the weight the state is asking to carry. I rest my case.
Mr. Hawes, do you have response?
No, Your Honor.
Okay. Mr. Badon, the Terry v. Ohio is also covered by Kansas case law, including Strickert v. Kansas Department of Revenue, which is 58 Kansas 2nd 1. It's a 2020 case. Review by the Kansas Supreme Court was denied August 31st of 2020. And says what you've said also, a traffic stop is a seizure under the Fourth Amendment in accordance with Terry. And there has to be reasonable and articulable suspicion that the driver has committed, is committing, or about to commit a crime. What we have on the night of November 28th, 2025, Trooper Tall observed headlights coming at him, traveling at a high rate of speed. He had the tone. After he made the visual observation of the high rate of speed, he clicked his radar button to check the speed of the vehicle. The speed of the vehicle per radar was 99 miles per hour. There were no other vehicles in view, and the video confirms that. At the time, yours was the only set of headlights you could see. A vehicle had passed in front of you several moments before your vehicle. Then you see a set of fast-moving headlights, and you see him pull over, turn around, and he's testified at that point he had checked your speed with his radar. Now, that gives him reason to stop the vehicle. Okay? You make a big argument based on the officer saying he observed you traveling at a high rate of speed. As he's testified, that means going beyond the speed limit. Then he checked you with radar. Okay? And that's in conformance with his training on the radar. First, you visually observe the vehicle moving too fast. There's a tone given off by the radar unit. You then hit the button to check the speed, and it checks the accurate speed of the vehicle. In this case, your vehicle was traveling 99 miles per hour. Okay. Old radar used to require tuning fork tests be done before and after the shift, at the beginning and the end of the shift. But newer radar units don't require that. As the officer has testified, this particular unit no longer requires the tuning fork test. They no longer keep old logs of the tuning fork test because they don't do them anymore. The unit itself has a self-test. You press the button, it goes through its internal calibrations. It says pass if it's working right. It says fail if it's not working right. Officer Towle has testified it was pass both at the beginning and the end of his shift. Okay. The requirement now for recertification is once every 3 years. Now, you were 30 months into the certification, but 30 months is less than, which is the 3-year requirement for recertification. So his radar unit was certified at the time he checked your speed. The unit indicated it was working properly. He had the visual observation of your vehicle traveling at a high rate of speed, which he has testified means above 75. And then he checked it with radar and was confirmed 99 in a 75. Okay. He then stops you. He approaches you, goes to identify you. You tell him you only have your identification card because that's the way it's done in Georgia. The officer has suspicion that you have a driver's license issue. He goes back, calls it in. Within a few minutes, they confirm that you are driving revoked, that your license in Georgia is revoked, and you have no other valid license in any other state. He then approaches you and arrests you for driving while revoked. He then does the pat-down search for his safety, your safety, and to make sure you're not taking contraband to the county jail. As he pats you down, the search incident to arrest, he discovers the two containers, the two small plastic containers that contain what he recognized to be marijuana joints. Okay. So at that point, the officer certainly has gone from articulable suspicion your vehicle moving at a high rate of speed to a probable cause when the radar confirms you're going 99. He stops you, then he's given the information you're revoked. That now gives him probable cause to arrest you for driving while revoked. And then based on the search incident to arrest, he finds the marijuana, which we also have the lab report confirming what the officer had observed, that those were in fact marijuana cigarettes. So for those reasons, the court is going to deny your motion to suppress. There is no requirement that the officer stop and document every little step at the time it is happening. There's no, the fact that you point out that he doesn't enter it into his log until 87 minutes later has no bearing on what he observed. It happened at the same time. There's things that have to be done. He's dealing with you, he's arresting you, he's taking care of procedure. He gets around to doing his paperwork. It's 87 minutes later. That's not very long. The court does not find any doubt created by the fact that he didn't write down the speed for an hour and 27 minutes after it happened. Okay. He visually observed you at a high rate of speed, got the tone, checked you with radar, and you were going 99, and everything stemmed from that. So each step along the way, the officer did what he was supposed to do as an officer. So there is no reason to suppress any of this evidence. Your motion to suppress the evidence is denied. Accordingly, your motion to dismiss the case is denied. Now, we need to set this for trial. You want a bench trial or a jury trial, Mr. Madone?
I'll do a bench trial.
You want a bench trial?
Yes, Your Honor.
Okay. Okay, Jess,
Yes, Judge.
we need to schedule a bench trial.
For how long, Judge?
How many witnesses do you anticipate, Mr. Haas?
One witness, Your Honor.
Okay. How many witnesses do you anticipate, Mr. Madone?
Just one.
Okay. So why don't you give us half a day, Jess, morning or afternoon? Now, Mr. Madone, do you want your trial in person?
And that's where they cut it. So I don't know what his trial date is. I don't know when the next hearing is. But I'll be keeping my eye open for it. Those were fun ones. Yeah, Chris, you gotta listen to the officer's testimony first from when the prosecutor was questioning the officer. Because the officer specifically says that the term high rate of speed means in excess of the speed limit. I know. Tragic. I got Tiny Kitten in the house. I had to let Billy out of the house, and I had to put Snitch in the kennel because Snitch will attack Tiny Kitten, and Tiny Kitten needs to eat. This is her din time. Oh yeah, so I had fun. That was good. I liked the first guy, the judge muting him as he was ranting. 88 years old, 10 DUIs, and it's elder abuse to keep him locked up when he fled to Mexico, threatening the judge with a 10-year felony because he's not letting him out. What? Saying that he's lived in his house with his wife for 27 years and that he's no risk of fleeing. Well, he already fled once. So You can't use that argument, sir. Oh, yeah. Unfortunately, any sentence that he gets is pretty much a life sentence. But that's the path that he chose. Those are his consequences for his actions and his choices. I don't believe that he did 2 years of rehab in Mexico and doesn't remember the facility that he did it at. That doesn't make any sense at all. Yeah, because nobody can cross the Mexico border. It's harder to get in to the United States from Mexico. But I don't think they're gonna stop you going. I know. But I mean, you can't please everybody. You know? I know. It's one of those. It's just one of those things that, you know, they say it how they say it, and could they be saying it differently? Yes. Does it mean anything differently? No. It's just what we prefer. It's like someone saying moist or damp. You know, some people are really, really upset when you say the word moist. You know, because they don't like the word. Oh well, it means the same thing. Oh, guys. Oh, Otto, I'm sorry. Hello, Otto. No. If Charlie could remember what state or what judge the case that he claims is really, really good is from, I probably have it. We can play Wheel of Judge. I'm sure we can find one of those like wheels where you put in info and then spin it and it randomly selects things, and then we can just search that judge in the archive drive and watch random cases from random judges. Let's see here. Hold on. Give me 1 second, guys. Give me a minute. All right. All right. So all right, let's get rid of these. And let's see, we've got Simpson. We've got Hesselink. We've got Otsego in general. We've got Gauthier. Gauthier, whatever. We've got Middleton, Mertz, Monk, civil docket, just a random. Let's see here. I know his name. I know his name. He likes scones. Elmore. I can't see chat at the moment, so I'm winging it. Let's see here. Yeah, we can add body cam. That can be the bonus. Let's see here. Any other suggestions before I spin the wheel? Wheel. Oh, judges. No. Oh gosh, what was? Ooh, golly, I'm trying to think. There was one that I really, really loved. I loved him. Oh yeah, Oakley. We got Oakley. Oh man, he had the best sentencings. And he hasn't been on in forever. Where is it? Can't even find my own dang logo. Okay, Judge Wiggins. I don't have. Oh wait. Oh, I do have Wiggins. What am I thinking? Thank you, Wiggins. He's in the house area, I believe. Houston, I think. Are you referring to Monk, the one with the long curls? Or there's another one. Well, you said Wiggins. And then you texted me something else. Oh, you texted. Okay, hold on. Well, I'll have to send that. Oh. Sorry, I can't run that. That's a different channel's content. I can't run that one. Sorry. If it was a raw file, well, I might be able to find the raw file, but I'll look for it. Oh, Mogan. I don't know a second blonde from Wisconsin. Mogan. All right, I think that's enough. I mean, We'll get something that we like, right? Right? Bald guy with glasses never wears a robe. Older white gentleman, kind of a smart arse. Cooper? I don't think Cooper's a smart arse. Scotchless, and Hunter. Colin Hunter. And Scotchless. All right, there. I think we got plenty, right? Right? Squishy, what was the what was the judge that he hasn't been on in a long time? He had glasses. He was kind of no nonsense. No, not Norbeck. I have Norbeck, but I think I've gone through all of my Norbeck. Like, I've literally put every Norbeck that I have into my editor and systematically gone through it to find all of them. I don't have much Judge Fleischer. I don't. Judge Fleischer, I had him on the drive that got broken by Ava. Almost all of my Fleischer. I mean, that was tragic. I lost a lot. All right, guys, we're going to spin this wheel, or we're just going to add names all night. Oh, we got a Middleton. Yay. Now, one for New Middleton and one for Old Middleton, or two for Old Middleton. One for New Middleton, like we'll go and watch today's stuff. Two, and we just go randomly select something from the archive drive. I want to see some ones and twos. One. We got 1. All right, I guess we're going with 1. We're going with today's stuff. All right, let me go here. Oh, my lip. Like I said, I just had the fillings done yesterday. And I got this one little spot on my lip that's driving me crazy. All right. Mitt Lemon is so boring. Get Hunter up. I've got all of Hunter's from the last few days. Oh, Judge Stevens from Texas. Yeah, I forgot about him. I got lots of him. Oh my goodness. I've got so much Stevens. What am I doing? Okay. Share screen, Middleton. Share. Okay, so we've got misdemeanor sentence. Oh, that's scheduled for 9:30 in the morning. Well, 9:24 because he's got to have his 6 minutes to chat with all of his fans. Special defense motions, misdemeanors. I like sentences. Is he talking to?
While not an ex-
Salvador Villafuerte Ferrer. Good morning, Vivian. Thank you for joining us again.
Good morning.
I'm going to swear you in again. You were sworn in a little earlier this morning, but I can't see you. Is your
I kept my camera off so I make sure I can hear clearly.
all right? Would you please raise your right hand?
Yes,
You swear or affirm the best of your ability you will interpret these matters from Spanish into English and English into Spanish.
I do.
Oh,
Would you state your name for the record, please?
Vivian Montero, court interpreter 18369.
oh, I'm gonna that echo. I'm gonna skip through the one with the interpreter because the echo is just awful. Hopefully it's not his new courtroom in general.
That's good news.
Good night, Jerry.
This is file number 26530FY, People versus Rayanne Ross. She's here with her lawyer, Mr. Ross Truckee. Ms. Ross was arrested when they executed a search warrant at a house in Three Rivers on March 22nd. I think she's hanging around with the exactly wrong people. Anyway, she had some methamphetamine that was attributed to her and she accepted ownership. She pled to use of methamphetamine and Mr. Truckee indicated he would be asking for 7411 conditions. He's here today. He's provided me with a recovery program attendance log and a bunch of notes from Pivotal. So that's good to know that she's plugged into some services. Mr. Truckee, what would you like me to know?
Thank you, Your Honor. Ms. Ross has made my job easy. She got plugged into recovery services as soon as she bonded out of jail. She took accountability for her substance use disorder and the criminal aspect of it. She stayed in regular contact with me. She's made her court appearances. She's not relapsed. So often you see someone in her situation catch 2 more charges because after being arrested once, you start to glow bright red. But she's not.
Didn't we test her on the day and she was negative when she was, that was the other.
She's willing to take a test today.
No, I think we're good.
But for those reasons, and because of Ms. Ross's lack of a criminal history, we'd ask for 7411 probation to put up some guardrails for her to continue walking her recovery path and to hopefully put this part of her life in the rearview mirror for good. I'd ask that you also consider reducing any discretionary fines as Ms. Ross isn't currently employed, although she is seeking a change in that circumstance, and to allow her to continue forward making progress. Thank you.
Are you still at the 5th Street address?
No, sir.
Which was a drug house, and so you needed to get out of there. Where are you now?
In Three Rivers at a friend's house.
Okay, but you're not with Mr. Fraze anymore?
No, he's in jail.
Yes.
Is her speech just naturally slurred?
All right, what would you like to tell me?
That I know I messed up in my life and this was like a wake-up call for me and my addiction. And that I'm glad that I was recommended Pivotal because I've learned so much through IOP and they're very caring and supportive people over there.
Are you plugged in with community corrections? seeing the ladies from Community Corrections?
Yes, she was subject to community corrections on pretrial release, I believe.
So you're checking in with them?
I talked to him at the jail when I was there.
All right.
The
Well, Mr. Truckee, I think this case is appropriate for 7411 probation. The prosecutor's not here to provide input, but I suspect they don't disagree with that.
I guess for clarity, Your Honor, the pretrial release order does not indicate community corrections.
Okay. I'm gonna put you on probation under section 7411. We're gonna do 12 months. He did 1 day in jail, I think. We got arrested on the 23rd, 22nd, bonded on the 23rd. I'm gonna order 31 days jail credit. One of the 31 days ordered, 30 are deferred. So there's some jail hanging over your head, but if you do what I ask you to do, there won't be any additional jail time. The fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 probation oversight fee, and $480 probation oversight fee at $40 a month. $755. You are to do drug and alcohol testing as directed, continue your substance abuse counseling and treatment, sign a release, abstain from the use of alcohol or any other controlled substance. Do you use marijuana?
No.
All right, so that won't be an issue. I mean, marijuana is lawful for adults if they want to use it for recreational purposes, but when you're on probation, we prohibit it.
$750 is
I
not
think
bad.
you've taken some really good steps, not the least of which is having your partner locked up so he doesn't have access to provide you with narcotics, or at least methamphetamine. You've moved, you're going to Pivotal, you're going to support group. It's hard, they don't have a lot of NA groups. And a lot of NA is focused on fentanyl and heroin and opioids.
Because that's what
We don't have a lot of meth people doing support, but you're trying to do what we got. I don't have a probation referral form handy, but I'm just gonna have the officers sit you out to the counter. One of the probation officers will do an intake here in a bit. I'm gonna attach all this stuff that you gave me so probation can see how you're doing.
Okay.
All right, you might have to wait out in the hall. All the probation agents are here, but at least they're already in this building. So you go out and check in at the counter and they'll meet with you in a little bit.
Thank you, sir.
Good luck with everything, man.
Thank you.
Thank you, Your Honor.
Continue on that good path. All right, guys. Squishy sent me a case. Just give me just 2 seconds. So we're gonna switch it up. We're gonna watch Squishy's case. Do. I thought you DM'd it to me. Squishy, where'd you put it? You sent it. Yeah, I don't have it. You didn't DM me. Now you DM'd me. All right. All right, and share this tab.
All right, this is Donaldson v. Donaldson, case 22-6929 DM. Both parties are present via Zoom. Mr. Donaldson is present with his attorney, Mr. Cox. This is Ms. Donaldson's objection to the ex parte order. I'm assuming it was the 1/4/24 ex parte order that grants exclusive use of the marital home to the defendant, grants him attorney's fees, and that the plaintiff basically is not permitted to be in the home without written permission from Mr. Donaldson. Em, I've read your motion. What do you wish to add briefly to it?
Are you asking?
Yeah, it's
myself?
your motion. Yeah, it's your motion.
Oh,
Are you still in the house?
I am currently in the home, me and the children. Yes, sir.
Even though the orders have told you to get out?
Well, that says if I do not have permission, and I have permission to be in the home, I've spoken with Mr. Donaldson. Mr. Donaldson knows that I'm there. He
It
has
says written permission. Mr. Cox, does she have permission to be in the home?
She does not, Your Honor.
All right. Ms. Donaldson?
Yes, sir.
He says you don't have permission to be in there.
Your Honor, I actually do have permission. We have email communications back and forth. Mr. Donaldson knows that I'm in the home. We've been in communication with the realtor for the last couple of weeks. She also knows that I'm in the home. There has not been any express concerns about me being there. He did say that he was going to write something to allow me to be there. He has not provided that, but he has also not expressed at all any concerns. He comes back and forth to the home to bring the kids, and that's just how we have been we have been living in and living in the home.
What's your motion here
for? School for him every day.
You're trying to set aside this ex parte order that gives him exclusive use of the home?
Correct. He does not live in the home. He has his own separate home. He has moved out. And there's no reason to have that exclusive use. He filed a second ex parte without fulfilling the first one at all. He was in the home 60 days during the first ex parte, and he did nothing. So really, when you look at it, he had no grounds or a need to file the second one when he already had full access to the home and full authority to move about at his discretion. And so there has been no further disputes between us. He's left the home, and we've been both taking care of the kids, and he brings his son to me in the mornings because he doesn't have means to get them back and forth to school. That's the way that our kids get back and forth to school, and it's their foundational home as well. So it's just not in the best interest of the children, nor has it been a problem with me being there. And again, we have written communication back and forth that Mr. Donaldson does know that I am in the home. We do have emails to support that, sir.
Knows you're there. That doesn't mean he gave you permission, but I'll ask Mr. Cox. Mr. Cox, your response.
Your Honor, thank you. Your Honor, we've tried everything. We've tried ex parte orders. We've gone through.
I've had a hearing.
Certainly, you've had a hearing. The plaintiff has destroyed the garage door twice. She punches holes in the walls. This realtor I have is a very good people manager, and she's tried everything. We just can't get in. I've got an email from her today, very alarmed, saying that she's concerned that she's not able to sell this home, as it is nearly impossible to have showings. I have 4 showings set for Friday. Mrs. Donaldson said that she has left for a trip out of town and failed to put the key in the lockbox. Your Honor, it just goes on and on and on. I don't want to inundate you that with stuff, but the point is that she just will not allow us to get this house sold, either by destroying it or making it impossible to work with the realtor. The realtor just needs to be able to get this house sold, and we only can do that by having this ex parte order upheld. She has to be removed from the home. We've tried everything to try to get her out of the home, and she files these motions about how she was somehow wronged in the judgment of divorce. Just to kind of demonstrate how irrational this, Your Honor, we entered into an order before the judgment was entered that said, all right, so your 401k, Mr. Donaldson, is worth $103,000. But you, Mr. Donaldson, only have 14 days to tell us in writing what your premarital portion was. And he said it was somewhere between $30,000 or $35,000.
I know that 401k stuff supposedly held up the actual entry of the judgment. I don't care about that. It doesn't matter who did it. It only matters that I have in front of me a judgment of divorce that I am going to enforce the four corners of that, nothing outside of it, okay? And that judgment of divorce was entered on August 25 of 2023, stating specifically that the house shall be listed for sale immediately. There's no other way to put it other than it says immediately. We are now in February and it still isn't. I know that there have been ex parte orders. I know I had a hearing on it and said it's got to be done. It was objected to my order. The judge has found on more than one occasion that the house will be turned over to Mr. Donaldson because it can't seem to get sold in any other way. I know there are attorney's fees that are now due that are part of a lien on the house that you're supposed to take her portion of the house, or her portion of the equity for some of it. I understand. Isn't that correct?
Yes, Your Honor.
Ma'am, I don't know what else to do. You're just not abiding by a court order. I mean, I think I should have the police go out and remove you. And a court officer should set all your stuff out on the front lawn.
Well, I don't know what that would do for our children that I take back and forth to school that he does not have means to do. Well, he should care about the welfare of his children.
I understand
and he should know.
But I'm enforcing the order. The order. There's nothing.
Your Honor,
it doesn't.
Like you said, it's been February. It's 4 months past. He was in the house for 60 days and with an ex parte order in place the first time and did nothing. The house did not get on the market until January 30th, 2024. Those are not because of delays of myself.
It's because you wouldn't get out of the house like you were ordered to.
No one ordered me out of no one ordered me out of home, Your Honor.
You've been ordered.
We've been communicating with the realtor.
More than one occasion.
No, sir. No,
yes,
sir. Mr. Donaldson has emailed me, and we have email documentation that Mr. Donaldson is fully aware and okay with me being in the home. He has worked with me, and we have worked together to say certain things about the home. But he knows and fully aware that I'm there in the home. We communicate about the children, so he has had no issue with me being in that home.
It sounds like he has an issue with you being in the home. It sounds like he doesn't want you there. And y'all talk way too freaking fast.
These concerns are more so coming
out of the home.
He told me I would be allowed 30 days once the home is sold. The home has not been sold. It just got put on the market less than 2 weeks ago, Your Honor. And it's been over 4 months that they've had to do that with full authority to do it. That has not been on my delay because the court granted them full authority that they have failed to exercise in.
It took us a lot longer because we had to get a bunch of ex parte orders in order to get the realtor to get anything done. And
that's not true. You had your order from September 26th, and he did not move out until December 1st.
What are you seeking today? Because, ma'am, this is the same thing that's been litigated that I started back in, I think it was.
Because it should have never been able to been filed in the first place, and it also should have never been granted because it had no grounds or no means.
Sorry, but I granted it, then the judge upheld it, the judge did something else to uphold it, and again, and I'm upholding it again. It's a court order. You just don't seem to agree that the court order should be issued because you don't think it should. I'm enforcing a judgment that you signed. You signed it. You agreed to it. At that time, on August 24, you agreed to it. And you agreed to the fact that the house would be immediately listed for sale, and it didn't, all right?
That's on me. That's on the defendant as well.
There is nothing that I can get done, according to Mr. Cox. The realtor is saying, I can't even do 4 showings today. Is that
That's not true? Your Honor, they're having excuses after excuses when they've had multiple.
No, you've had excuses after excuses why you do not follow the court order.
They did not enforce the court order. They did not. Mr. Donaldson did not tell me.
Then that's what we should do. I should order the police to go out and remove you because then they will follow the court order. Okay, they want you removed from the home, and if that's what you're asking for, just.
No, that's not why I would not want to put my children in that position. I would not ask for that. And I don't think Mr. Donaldson would be asking to put his children in that position.
He's running out of
He has children. So even whatever his personal things are, it's not in the best interest of the children. This is also a family-related issue.
I am asking that she be removed from the home today. We've got to try to get these 4 showings in. And I'm not trying to add more fuel.
The showings are already scheduled. They're
Try
already
not to
scheduled.
interrupt
I've been
you.
in communication
I
with the
just
realtor.
asked
They're
Mr.
already on the
Cox,
book
ma'am.
and confirmed.
Silence. I'm going to mute you. Mr. Cox.
Your Honor, one of my obligations under the judgment is the child has a disability that provides him with a trust that provides income to the child of $3,600 a month. I haven't even been able to deal with that with the probate judge, as Judge Hillary ordered me to. And she is simply collecting the child's money every month, not working, and obstructing the sale of this house. Your Honor, we're at a desperate need here
What
because
does
we
that
may
have
lose
to
the
do
house.
with this order while we're here today? First, you're bringing up the
And you're
child
bringing
support
up
order
everything
that
under
has
the
nothing-
sun, and that is not
that is
inappropriate.
related
It has
to the
nothing
issues
to
today.
do with it. It is enforcing a court order. Enforcing a court order, and you're supposed to be out of there. And that is a
court order
order.
also enforced him to do things that he has not done either. That the court has just
latest
put a
order
blind eye to. He's supposed to pay the portion of my car. He has not done that.
And that
also
isn't what
is a
we're
court
here
order.
for.
It's
Stop.
a court order.
Just mute her. Mr. Cox.
Woman, start with yourself first. Clean your own room before you bitch about the rest of the house.
I muted her because this is just going nowhere, and it's hit my office and Judge Hillary's office over and over. We've done everything to try and be reasonable, and she just won't do it. Now, I don't know that Mr. Donaldson wants her put out in the street today. I don't know. I'm assuming you're asking for costs for this motion now too.
We are, Your Honor, and it's horrible to say that. I mean, he doesn't want her put on the street, but he knows that we just have no choice. We can't get this house sold. She's going to stop everything that we try to get it sold.
Can you check with your realtor and see today if she can at least get 4 showings in today? Does she have the ability to do that?
We don't have a key to the house to get in the house.
There's no key to the house because Mrs. Donaldson won't give it to her. She said she went on a trip and can't give her the key today, so the 4 showings wouldn't happen.
Ooh. All right, well, this is her motion to object to the ex parte order. I find her motion to be frivolous. It's the same thing that I have done and Judge Hillary has done on this case since this started. And I think the first hearing was probably back in September 21st. I think at that point her counsel was also there, and there were attempts to do, change things. I don't think an order actually got entered, written order, because of objections and stuff until November. On this matter, there's been an ex parte order for exclusive use and possession, attorney's fees. Plaintiff is not permitted in the house without written permission. Mr. Donaldson, I want you to raise your right hand. Yeah, that would be your other right hand. You solemnly swear or affirm testimony given in this case to be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, put your hand down. Have you given her permission to reside there for some period of time?
Yes, until the house sold. Yes, I did allow. I was giving her permission to stay in there, but with all these back and
How
forth,
recently did you give her that permission?
it was a couple of weeks ago.
And if you've given her permission to stay there, you've given her permission to stay there. How
Yes.
long?
Well, until the house sold. Until the house sold. But it's like she's blocking from the house to get sold. So I have no choice but to say, hey, she got.
Are you revoking your permission then?
Yes.
You did this, dude. You created this situation. You created this scenario. What are you bitching about? You told her she could stay there till the house sold. You know what she's like. Of course she's going to block the sale of the house. She's a grifter. She's using her own child and taking the money. Oh, man. Dumb. Sorry. I had to speak it in his language.
as of today?
Yes.
All right. Mr. Cox?
If there's any hope that we believe she could demonstrate a single shred of cooperation with the realtor, but she can't. It's impossible.
I know, but right now I'm saying he is entitled to it, but he let her stay there. All right. He just told me, and I believe him because he's under oath and everything. He said he gave permission, but he's revoking it as of today. And that should be put in writing to her from him. And then, I mean, she's learning of it today. Ma'am, I'm probably going to give you like a week to move out because he's revoking his permission today, unless he gives you other written permission.
Can she be ordered to cooperate with the showings, Your Honor?
Yes.
All right, thank you.
Yes. Ma'am, you're going to be, you're muted. I can't hear you. I'll unmute you in a minute, but you cannot stop talking when I'm talking or anything, even when I'm doing that. You are ordered to cooperate with the showings that are scheduled for today. You said that they were scheduled. You are ordered to do that. You are ordered to get the keys or availability for those showings today and any other showings that this realtor schedules. You'll give her whatever is necessary to get in and do the appropriate showings. You will not in any way cause damage or something to the house to make it less saleable. I'm denying your motion today regarding your objection to the ex parte order that remains in effect. And as I say, I will give you 7 days to get out of the house unless something else is brought up by Mr. Donaldson and he agrees to some other time or something like that. Mr. Donaldson, you...
And taser just for the hell of it, please. Just for the fun of it. No other reason. I can't stand her. So, yeah. I agree. Give her 72 hours. Boot her ass out. And, make her cooperate with the showings and just taser. Taser, please.
I got to tell you this. You can't come in and ask that she be removed and then at the same time give her permission. You either give her permission and you work with her or you don't. And if she doesn't do it, I'm giving 7 days for her to be removed because you've revoked your permission at this point. Anything else, Mr. Cox? I'm going to, Miss Donaldson, you can unmute and state what you want to.
She has to unmute.
You have to unmute yourself now. We've got it.
All right. Are you able to hear me now?
Yes, ma'am. I
I have already been in communication with the realtor. I am not just out of town. I have a sick father, much like the defendant, and I'm out of town. I'm in Cincinnati, and I'm here visiting him. He may not have much longer to be here, so I'm just here seeing him, and and Mr. Donaldson knows that. But I've already spoken and communicated with the realtor in reference to that. The showings that were scheduled for today have already been rescheduled and confirmed for Monday. We've already talked about that and talked through that with the realtor. She is aware of that, and I am also aware. And I did apologize for my error on this one time that did for this particular time. I have offered also to repair the home on more than one occasion. That information is there. I haven't been the one to I've been the one trying to get the home repaired because we can make a lot more money than what's being offered on the home currently. And so I've been trying to work with both Mr. Donaldson and the realtor to at least allow those negotiations to be made, because those are one of the main concerns that a few sellers have. The house is currently on the market. They do have all the photos that were needed that came in. They came into the home. We got it on the market. We just had an open house Sunday, February 1st. So I have been in cooperation. There were 22 people that came through the home, and there were communications after the home. So there has been steps that has been taken that I have cooperated with. They've gotten in the home. I've made sure to keep the home in decent condition and to make sure that it was presentable for the guests. And I am hopeful that Mr. Donaldson will allow for us, I say us because it's me and his children that he would be putting out on the street, not just myself, because this affects the whole family. And I pray that he does give us permission to stay in our home because it is still our home. I handled all of our affairs for the first 13 years of our relationship, all of our business affairs and personal. And so Mr. Donaldson, he's not a big negotiator. And so he expresses to me that most of what is being done with the home is being told to him what he's doing. He's not really saying he's never really been that person to take the lead in that. That has always been me. So I have been trying to be at the table to negotiate the best rates for both him and I. And also give options for these people that are going to buy it because we can make more money. We can make up to $50,000 more money that his realtor has said that we could make. And I'm trying to be able to do that. So we can both put more money in our pockets for ourselves and our children that we both need.
The house must
But I will be in
immediately be
cooperation.
sold. And it must be, it doesn't say anything in the judgment about repairs or anything. It must immediately
Correct.
be sold.
Yeah,
If
it
you
wouldn't
are
stop
going
the
to, if
selling
you are going to
or delay
talk
it.
to Mr. Donaldson about something, you're not being prohibited from talking to him or something, but you are prohibited from interfering with the immediate sale of the house. Okay, you can't hold it up because I want to repair the living room.
It wouldn't
that
hold
kind of
anything
stuff.
up. It wouldn't hold it up.
Yes, it would. You
We
gotta
do it
fix
before
it.
the
So don't
closing.
give me
The
that.
same
I mean,
thing that we've done when we
ma'am,
purchased the house.
ma'am.
So, yeah, same. But go ahead.
Well, thank you.
Honorable.
I'm
So
just
go ahead.
telling you that it will hold it up. I know what it does to fix a house. It holds it up. You gotta do the
It's mine. I already
Ma'am,
had someone come in
ma'am.
and give estimates, but okay. All right.
Jesus. That's going to be the order of the court. She will fully cooperate. Obviously, if she doesn't cooperate with the Monday showings, you can come back and get an immediate order to have her removed. All right. I know you've got them before, but with whatever, because she said she's got it all set for Monday and everything is set up. Okay. And that's her own words to me right here. And if she violates that, I'll use that against her too. Unless you agree, she's to be out next Friday. I will reserve costs for Mr. Cox. You can, you'll be able to bill for your time, the amounts and stuff like that. I'll reserve them for right now for this hearing, only because unless stuff goes the way it doesn't seem to be going, there'll be more. And I will grant costs to you at that time, Mr. Cox. That's going to be the order. If Mr. Donaldson and Miss Donaldson want to cooperate and give more time or do whatever, that's fine. But you're here telling me, Mr. Cox, that he wants this done now, doesn't want to make repairs, basically, just wants it done, just sold.
Can't blame.
Is that correct?
Yes, Your Honor, we're just trying
I
to
understand.
allow our realtor to do her job, and Mrs. Donaldson is not allowed to do it thus far. So,
And if the realtor comes in, ma'am, and says you're putting anything in her way, I'll have the police come and remove you. I'm tired. I'm done.
Send them now.
So that'll be the order of the court. Anything?
thank you.
All right, thank you.
Have a good
You'll
weekend.
draft the order, Mr. Cox.
Yes, Your Honor, thank you. Have a good weekend.
You too, thanks.
Wow, that was crazy. What a witch. A little bit. Yeah. I'm thinking there's a reason. All right, I promised Charlie we'd do some Hunter. And I got lots of Hunter. I've got so much Hunter that I've stopped watching Hunter when I get it because there's just I haven't put them together for a while. That was Michigan. All right, so let's see here. Today's hunter. We've got 1, 2, 3, 4, 5, 6. 6 from today. This one's 20 minutes. 19 minutes, 20 minutes, 7 minutes. 7 minutes is probably just a reset hearing. All right, we'll go with 2101.
Okay, welcome back, everyone. This is, again, the matter of Keith DeVar Jr. versus Brandy DeVar. We are here now again because I've gotten a copy of a judgment of divorce. I'm just flipping to the last page to be sure, and it does appear that there are signatures by each of the parties and each of the attorneys. And so what I need to do then is Mr. DeVar and Ms. DeVar just put you both under oath. The attorneys will have some questions for you. Sometimes I will as well, sometimes I won't. But if each of the parties could raise your right hands, please.
These are usually so boring. They literally just confirm they want to get divorced, and then they're divorced. We can watch it if you guys want. Otherwise, we'll move on to a different hunter clip. Say yes to continue and no to move on. First person wins. I'm waiting. In Oregon, you just turn in your paperwork. No, I don't think his hands look like baby hands. Move on. Okay, yeah. Yeah, I don't get the... See, Hunter, the divorce cases, unless they're super long, they're just going to be boring. You're just going to get people saying, yes, I want to be divorced. And that's it. There's nothing fun about it. All right. Let's see what else he had today.
Mr. Sizemore, despite your location there in the jail, have you generally been able to maintain contact with your attorney?
Yes.
Glad to hear that. Mr. Gurmurthy, what should I be aware of? This is our first status conference in the circuit court. What should I be aware of?
This is our first status conference in circuit court. The offer in this matter is to plead to delivery of fentanyl less than 50 grams. That's a 20-year felony. It's a degrade, D for Delta, degrade offense as a habitual third offender. The remaining counts, count 1 and 2, and the habitual fourth offender notice would be dismissed. Based on that offer and that representation and the scoring guidelines, Mr. Sizemore would like to take advantage of that offer and tender a plea today. Just for the record, Judge, I did score Mr. Sizemore.
Mr. Gurmurthy, I'm not going to permit any further discussion about guidelines, and here's why. You well know, and the attorneys well know, that both of you have an obligation to score guidelines and have a predictive measure, but you also both know that I'm the one that ultimately scores the guidelines. So I'm not going to permit that language to be utilized in a plea. Mr. Sizemore, if he wants to plead, can plead, but it's not going to be based upon a representation of guidelines, because that representation is not binding upon me and I'm not willing to accept it as binding upon me. So I can go through all of that with Mr. Sizemore, but you use words that are not acceptable to the court. This is not being proposed as a sentencing agreement. If it is, I reject it because I don't know anything about this case. So if you want to put on the record what the guidelines calculation is that you have, that's fine. But Mr. Sizemore is absolutely not going to be entering a plea under any suggestion, threat, promise, or anything related to guideline scoring, because that's not up to you and it's not up to the prosecutor.
Yes. Oh my God, I love this judge. I love this. See? For the win. All right. I'll be right back, guys. I just need to run to the ladies' room. Dang it. I don't want to miss this, but I have to. For a minute.
That is correct. Mr. Sizemore is aware of what the guideline estimated range is if he were to go to trial and what the guideline range is based on the plea. And I was simply going to state, Judge, that the plea offer was to, what I stated, the delivery of fentanyl, which is a degrade offense, as a HAB third, sentencing within guidelines.
The semantic language that you used, though, conveyed something different, and that's why I corrected the record. And what you just stated also involves a sentencing agreement, which again, because I know nothing about this case, I'm not going to permit. If the attorneys want to take some time to discuss specifics with me, I'll be open to that discussion, but you just said a sentence within the guidelines. I'm not willing to bind myself to any type of sentencing agreement until the attorneys bring forth sufficient evidence on the record. Was that part of your intention today, Mr. Gurmurthy, to try to suggest specific information on the record by which I might consider a sentencing agreement?
I did not plan on that, Judge. I was simply going to indicate that based on my discussions with Mr. Sizemore and the offer that was made, he was tendering a plea, and that plea would be within the guideline range. Whatever that
That's not
guideline
accurate.
range is.
That's not accurate, Mr. Gurmurthy. Again, you're inserting language into this plea that I'm not permitting. I'm not permitting a sentencing agreement in this case because I don't know anything about the case. I might sentence within the guidelines that I determine. I might sentence below it. I might sentence above it. But that's subject to a lot of different determinations of which I know nothing.
Right.
And so when you use language like that, it's unacceptable to the court. I'm not agreeing to a sentencing guidelines range. I'm not agreeing to sentence within the guidelines range because the attorneys haven't told me any information about the case.
If the court's willing to hold a COBS agreement or an informal COBS, I would ask the court to do so, so we can provide that information to the court, or we can do
No,
it on the record. Either way, Judge.
I'm not going to have an informal COBS conference. I generally don't approve of COBS agreements because they generally limit my discretion. And one of the things I've learned in my role as a judge is that discretion is important. And it's important for me to hear everything before I make a determination. So while there are limited times where I've approved of plea agreements that contain a sentencing agreement, they're limited to those circumstances where the attorneys in advance of a plea hearing have given me specific and significant information. Because every time that I can recall that I've accepted a sentence recommendation from attorneys where I don't know the specific information, it's ended up being a waste of time. Because what happens is I end up learning either more information than the attorneys supplied, not through the fault of the attorneys, but perhaps because they didn't know it, or I learn more negative information, or I learn more positive information, and all of that affects my discretion. So I'm not willing to go in the route that you're suggesting. If you want me to delay to have an on-the-record discussion about the background information that might relate to a potential sentence, I'll have that discussion, but it's not going to be during a plea hearing. It's going to be well in advance of a plea hearing so that I have plenty of time to hear the information, ask questions about it, hear from the prosecutor and any potential victim, although I don't predict that there's any victims here, but also learn all sorts of other imperative information. What is the defendant's potential criminal history? What are the potential guidelines? Are there any potential drug-related offenses? Are there rehabilitative goals that might be served? All of the information that I would get in a PSI that would guide my discretion at sentencing, if you're asking me to bind myself in any way, I would need all of that before I would ever consider a sentencing agreement. So I'm not trying to be difficult, but Mr. Gurmurthy, frankly, you know that that's the case with me because I don't often accept sentencing agreements for all of those reasons. So did you want some time to discuss with the prosecutor and see if you could have a conference on the record with the court about whatever factors you want me to be aware of?
Yes, sir.
Mr. Ziegler, did you have any opposition to that practice?
In terms of an adjournment to
have that on the record discussion?
Yeah, I don't have any objection to that procedure, Your Honor.
Was it ultimately going to be the people's suggestion as well for the court to potentially consider a sentencing agreement?
Yes, Judge, and as Mr. Gurmurthy stated, the only agreement would be that whatever the sentence would be, it would be within whatever guidelines range was ultimately calculated by the court.
Well, and that's fine if that's going to be proposed, as long as the court, again, has significant reasons behind it. If it's just a blanket, I'm going to sentence within the guidelines, I'm likely not to approve that type of a sentencing agreement unless I know why. So it very well is the case that the attorneys know more than I do, and you're going to be able to offer me sufficient reasons where I might consider that, but I don't know those reasons yet. So, Mr. Sizemore, I want to repeat a couple of things for your benefit. I'm not unwilling to have discussions with the attorneys. What I am unwilling to do is to make considerations or predictions about how a case will end when I don't know anything about it. I'm in the unfortunate position in some regards that I know the least about this case probably out of anyone in this room. I know what the charges are. I know what the enhancements are. That's it. I haven't presided over the case for very long, and I don't know anything about the facts. The facts are what drive an ultimate sentence. So what I'm not telling you, or the defense or the prosecution, is that I won't ultimately be willing to commit to some sort of an understanding. What I am saying is I won't commit to any type of understanding that limits my discretion until I know a lot more. I'm going to grant an adjournment, Mr. Sizemore. Once the attorneys supply a date along with my staff, we'll have a hearing. It will be on the record. You're going to be here via Zoom to be able to hear what's said, because this is an important enough case that it's going to be done while everything's being recorded and everyone's present. So when that hearing takes place, I'll probably have some in-depth questions for the attorneys about what it means and what they think the case is, isn't. And then I'll be able to better be in a position to make a determination about whether I agree to whatever they propose. With that, will be an adjournment. I expect the attorneys to work with my staff to get that hearing date. And again, just make sure you don't need a writ because he's lodged in Wexford County. You can just make a call to have the defendant brought in.
Correct. If it's noticed on the docket, they'll make arrangements to have him appear.
All right. And if it's a separate, here's a better question. Usually I'm going to have this done on an off day, not on a motion day, just because sometimes we need a little bit more time. As long as you have a notice to appear, you can get that to Wexford County and they can have Mr. Sizemore present.
Yeah, the jail should have copies of all your dockets and make those people available, even if it's an off day.
Okay. And anything else from the people for the court to consider today?
No, Your Honor.
Anything else, Mr. Gurmurthy?
No.
Okay, thank you. We'll see everyone at that upcoming conference between the attorneys, the court, and Mr. Sizemore.
Thank you.
Thank you.
All right, Mr. Sizemore, if you could be so kind, we have up next from Wexford County, Kendra Hiddle. Could you let jail staff know that we're ready on her case?
Yep.
Thank you. It's bringing in an unidentified Moto V device to see if we can identify that person in between. I just brought in a device into my hearing room. It's listed as a Motorola Moto G 2025. Please unmute yourself, start your video. Hit the button on muting and then state your name for the record.
Dan Rowe.
I'm sorry. Oh, Daniel Scott Rote.
Yes, sir.
Okay, thank you. Let me call your matter. Are you ready, Mr. Rote?
Yes, sir.
All right, the court is on the record then. We call the matter of People of the State of Michigan versus Daniel Scott Rote. This is file 26-5179FH.
Ryan Ziegler on behalf of the people, Your Honor.
Michael Horowitz on behalf of USDO.
Thank you. So, sir, you are Daniel Scott Rote, correct?
Yes.
Mr. Rote, we're here for a status conference today. It looks like this is the first status conference before the circuit court. Have you been able to maintain good contact with your attorney since the time it came to this court?
Yes.
Mr. Horowitz, what should I be aware of in terms of preparation? Do you need time to file motions? Do you have a resolution? How should I prepare?
There is a resolution, Your Honor. We actually bound this over from the district court to Your Honor's court with the intention of entering a plea here.
All right.
The plea agreement is for a plea to the aggravated stalking, no additional charges or any additional charges dismissed, and no habituals. And the people are also going to be dismissing 2 other cases. One is a domestic violence in the district court, and the other is an FY case in the district court for a misuse of license plates or something. That, as part of this agreement, I think that wasn't supposed to be charged. It was charged subsequent to us accepting the agreement. So I think now it would be dismissed. It just, Mr. Rote having to go to jail on that post bond on it was just an additional, I guess, inconvenience. But I think that's the entirety of the agreement. Is that correct, Mr. Ziegler?
That's all correct, except that the stalking is going to be an attempted aggravating stalking.
Correct. Thank you.
Everything else Mr. Horvath said is correct, Your Honor.
All right, and so the attempted stalking, I want the attorney's representation regarding how they think this applies, because the attempt statute, to the court and to several of my bench colleagues, can be read in a couple different ways. How do you interpret an attempt as a 5-year offense? Mr. Ziegler, how long do you think the maximum would be as an attempt to a 5-year?
So, Your Honor, I've had this come up a couple times. In my reading of the statute has always been that it says anything 5 or more becomes a 5, but there is case law that suggests that everything is cut in half.
And I'm aware of both of those things, but that's why I want the attorney's agreement. And if you have one, that's fine. But the inconsistency leads to inconsistent results or expectations.
So given that the courts interpreted the statute in that way, Your Honor, it would be my belief that it would be a 2.5-year max as an attempt.
All right. And do you concur with that?
Yes, Your Honor.
All right. And are you aware of as well, defense counsel, that there was potential that the statute may read differently than case laws interpreted the statute? If you're not, let me suggest this. You should research it because it potentially affects the way different courts do things. I'm happy to adopt the party stipulation that the attempt in this case for this 5-year offense would cut the maximum to 2.5 years, as long as there's clarity from both of the attorneys.
That was my expectation of what the attempt would do.
And that's what I'm willing to do, but I would just encourage you to look at the issue more carefully. The statutory language, in this court's estimation at least, is directly contrary to the way Michigan Supreme Court cases have interpreted it. And so sometimes what I've found in talking with other judicial colleagues is that it leads to inconsistent application. And an expectation, obviously, for the defense is important as it is to the people. Anything else on that point, though, before we go forward?
No, Your Honor. Thank you.
Mr. Sigler?
No, Your Honor.
Mr. Rote, did you hear all of that?
Yes, I did.
Do you understand the terms of the plea agreement?
Yes.
Did you want to go forward with the terms by accepting a plea?
Say that one more time.
Did you want to go forward with a plea agreement by accepting a plea?
Yes.
Raise your right hand, please.
Yes, I am.
Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, sir.
So, Mr. Rote, under this plea agreement, you're going to be pleading guilty to an attempt count 1. Attempted count 1 would be attempted aggravated stalking. In Michigan, there's not consistency between a statute and case law, but the overall effect is this. In this courtroom for this offense, an attempted aggravated stalking is going to be punishable by a maximum of 2.5 years in the state prison system. Do you understand that?
Yes.
And the maximum fine you could face for that offense is up to $5,000. Are you aware of that?
Yes.
The benefit of the plea agreement has several layers. The first layer is that the prosecutor dismissed the charged offense, aggravated stalking. Are you aware of that?
Yes.
Next, the prosecutor also dismissed the habitual offender third offense notice that was filed. Are you aware of that?
Yes.
And then the prosecutor is also going to dismiss 2 other files that currently exist in the district court. Do you understand that?
Yes.
They're dismissing the habituals? That he's done this before? He's a danger.
One apparently is a domestic violence allegation, and the other one is an undescribed but a FY or a felony charge that related something to a license plate. But in any event, those are going to be dismissed as a part of the plea agreement. Are you aware of that?
Yes.
So do you understand the benefit of the plea agreement and having those other files dismissed and having the habitual third dismissed and having the aggravated stalking reduced to attempt aggravated stalking?
Yes.
And do you understand the maximum penalty for attempted aggravated stalking?
The max?
Yeah, you understand the maximum penalty.
Not enough.
That's 5, right? Is max?
The maximum is 2.5. The maximum for a completed aggravated stalking would be 5 years. But under the attempt statute, the way the attorneys are viewing it and the way the court accepts for this hearing is that that stalking aggravated would be 2.5 years maximum. Do you now understand?
Yes. Yes. Yes.
And did you want to proceed forward with a guilty plea under those circumstances?
Yes.
As to attempted aggravated stalking, then, how do you plead?
Guilty.
If you plead guilty, you will lose any automatic right to appeal. That means you have to ask the Court of Appeals for what's called leave to appeal. It's not automatic. Are you aware of that?
Yes.
If you plead guilty, you give up all of your current trial rights. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have the right to have the witnesses against you appear, see, hear, and question those witnesses. And you would have the right to have the court order any witnesses on your behalf be ordered to appear at trial. You'd have a right to remain silent during your trial and not have that silence used against you, and you'd have the right to testify at trial if you wanted to. But if you plead guilty, those trial rights are gone. Do you understand that?
Yes.
And because you're giving up your right to trial itself, you also necessarily would give up the right to challenge other things that might have occurred at your jury trial. Do you understand that?
Yes.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yes. Yes.
Is it your choice to plead guilty?
Yes.
The prosecutor claims that this happened somewhere around February 21st of 2026 here in Kalkaska County. Do you agree with that?
Yes.
And the prosecutor alleges in his charge that you engaged in a willful course of conduct that involved repeated or continuous harassment of Angel Rote, and the conduct being such that it would cause a reasonable person to either feel frightened, harassed, intimidated, molested, terrorized, or threatened, and that it actually caused Miss Rote to feel those things. And that at least one of the actions constituting the offense is in violation of a condition of bond. Did you hear those allegations?
Yes.
So were you protected, or excuse me, was Miss Rote protected by a condition of bond from you having contact with her?
She did.
And did you have contact with her in contravention of those bond conditions?
I did text message her. Yes.
Did the nature of the texts, the amount of them, or the other content within the text messages involve a willful course of conduct by you?
Yes.
And were those repeated text messages?
Yes. Some yes. Some yes.
Do you agree that those some text messages, which were done by you at the time that you miswrote, was protected from being contacted by you, in and of themselves, because of that circumstance, would cause a reasonable person to feel terrorized or harassed?
Yes.
Do you agree that Miss Rote, under the circumstances, did feel harassed by those circumstances?
Yeah.
Counsel, is there an adequate factual basis?
I'm satisfied, Your Honor.
I believe so, Your Honor. Thank you.
Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, Your Honor.
And are either one of the attorneys aware of any promises, threats, or inducements not disclosed on the record?
No, Your Honor.
No, Your Honor, it was a somewhat comprehensive agreement, and the attempt on the record today was to capture everything we had discussed.
All right, thank you. Mr. Rote, I find your plea is freely, knowingly, and voluntarily given, and there's a clear factual basis to support a finding of your guilt. So I accept that plea, and I'll enter it on your record. In just a moment, I'm going to have you provide your telephone number. That's so that the Department of Corrections can reach out to you and set up an interview time. The interview will result in what's called a 3-sentence investigative report, which will tell me more about these events and more about the background of you before I impose sentence. Following that, you'll get a date in the mail. That will be for an in-person sentencing hearing. So that sentencing hearing, like all in Kalkaska County, will be in person. You'll be here, so will the attorneys, and so will I. Do you have any questions about any of that?
No, I do not.
Go ahead.
No, I do
Phone
not.
number, please.
I paused it for 1 second because I am going to try to skip past this phone number. Oh, that was way too far. Hopefully this is enough.
71. Thank you.
Anything else, counsel?
No, Judge.
No, Your Honor. All right. Thank you.
All right. Well, it was the end anyways. All right, guys. I'm tired. I think we had a glorious night. We had cases I edited. We had a old Squishy Gardner case. And then we had the random wheel of judges. And we got Middleton. And then we had Charlie's request for Hunter. And now it's bedtime. You guys are so amazing, and I'm so grateful that you came and hung out with me and spent this time with me. I hope you guys know how much you mean to me. You are such a big, wonderful part of my life and piece of my heart. Thanks for coming, Otto. You were late, but you came. You guys are the absolute best. Be safe, be well, sleep sweet, and much love.